pardon to mention, madam, this is a reach appeal filed by the state. But as a result, my client is starving because his back wages were stopped by the government. And he is under
Is there any
financial
interim order?
arrest scheme, madam.
Is there any interim order in the appeal?
No, madam.
Then
It
where
is,
is it?
it is not yet listed, my lord, from the date of
Where
filing.
is the difficulty on your part? If there is no interim order, then
My lord, after filing of reach appeal, they are not disbursing my salary, back wages. Because
you file contempt?
contempt we have filed already disposed of.
what?
Contempt.
How it is disposed of?
Disposed of by saying your lordship's predecessor said that because of the read appeal is filed, contempt is no more applicable.
Have you challenged that order?
Content of bill.
Most of the many cases, my lord, only because of only.
There has been a lot of amendments in 2002.
Yes, my lord.
Which says that mere filing of an appeal does not tantamount to stay.
People cannot afford to challenge even if it's good. They cannot. Alright, you keep.
To mention, my lord, which is the I have challenged the highest of the
One at a time.
highest of the amendment of the elementary cadre rule 1990. This was also heard.
Why is of 1990 now challenged?
19, but in 2023, this case was filed. And this was hard at length. But my honorable ex-chief justice also kept reserve. But when he got retirement, they released from already from the Qatar, everything, my lord. So this is the cadre rule. Yes, and fresh content, my lord. Another fresh content. Yes. Fresh content.
May I permission to mention that there are two repetitions. It was in your lawsuit list, but subsequently it has been delisted. May I pray, may kindly be listed this week, because while the audience is, there is a likelihood of attachment. That is why I am praying. That's my time.
Two recapitulations, my lord. Yes, pending since November, my lord, not a starting.
Give all the slips. Please pass on all the slips.
Raise read appeal, my lord.
Finance.
Pardon to mention, my lord.
I interpret the month of March 2020.
I'll see to it. Give me at least some breathing time. I will definitely do everything. Don't worry.
My lord,
I will do it. It will be listed. Don't worry.
the respondent now filed contempt and issued notice already has been issued. My lord, this data will become infatuous, my lord. This matter may be urgent, my lord, and be taken up tomorrow.
To mention, my lord, this is execution pending, my lord. I have given the petitioner.
Execution before the division bench.
It's a recapitulation because the urgency of explaining, my lord. In the execution, my appeal will become infectious. It is not her. I filed on 10th of February.
The order, if it is implemented, then your appeal will become infructuous.
Lord,
Execution, why you use that
execution
word?
in the sense, my lord, I being the petitioner, I have challenged the committee award. The award is under execution now, so it will become infructuous. I filed it 10th February, fresh admission not even listed once.
Section 37 appeal.
MSMED award.
Oh, Chairman.
Beg your pardon, my lord, on the list, item 43 your lordship, I am required to file counter your lordship on the last occasion your lordship has clarified. Your lordship, I need some more time to file counter your lordship. I have only.
Let it be called, don't worry.
I give it.
Item number 31. Item number 31, both the parties present have some inconvenience. Can it be taken up next week or one week after? Both the parties are present.
Yes.
Interim order.
Okay.
Yes.
Interim order is there.
Yes. Let it continue.
My lord.
As requested by both parties.
Both the parties in the model is the period of 4 weeks from that.
My lord, I am in BC, my lord.
47. It is a similar matter, but batch of matter has a reduction of me. That's the point.
Parties make a mention of it. This is the matter when judicial employee disciplinary proceeding has been initiated. My lords. It has been challenged before the appeal committee of this honorable High Court. My lords, it has been performed. It was been listed before the honorable justice to chairman of the reproduction. It has been released from that bench.
Why?
Because he was a member of that appeal committee.
So it's an assignment to some other bench.
Yes,
So why you are mentioning it here?
it has not been assigned yet. My lords.
It will be assigned. That's an administrative side. It's an administrative side. Why you are mentioning in the court?
Item 15. Madam, item 15, let it go creation. Item 15, let it come creation. Item 15.
Come before the division.
Wrongly. No.
What do you say?
See chapter 1. Yes, madam.
I mean, hurry. Let us call. Yes, other side will be there.
There is no.
Call. Don't worry.
On item 42, there is a noting that one of the opposite parties died. So, but the problem is, he came as a Hindu public, so his substitution is not necessary.
He came as a.
Hindu public in a endowment matter.
Okay.
So his substitution is not necessary. For that I can do it, but I am mentioning because they have filed a counter also, the other clerks. I may need a 1 week time to file a rejoinder. Otherwise, I would have moved it.
He said that. You have filed a count. And gone it in.
Let us look at the file.
Yes. No, it's-
Let it be called. Yes, come on.
My lord, I am in BC, my lord.
Yes.
My lord, I am in BC. My lord, with the permission of the bench, my lord, a press writ appeal 3148 by 2024. The matter is involving the maintainability because under the doctrine of appropriate and reprobate, the person who has participated in the selection test and failed, he is questioning the selection process after 15 years. My lord. Can it be taken up any suitable date? My lord?
Give a memo, give the memo, sir, pass on the memo, it will be either on the
Yes, yes.
chat box or send any of your junior.
Obliged. Obliged. Deep obliged. Great.
Weekly list item number 1.
The chat box.
May it please your lordship. My lord, my lord is not audible.
Oh, I am not audible.
No, my lord. Now you are not audible.
Yes.
My lord, may I proceed?
The same point you are raising confiscation when there
Right,
is shortfall.
That's my lord.
That is, then we have fixed the matter. I think yesterday we both fixed the matter. When
Friday.
so let
Saturday.
it come on Friday. Sorry.
It is there on Friday because you kept it.
Yes. When we have directed this matter to come.
Today, my lord.
Okay. Okay. Yes. Sorry. I just noticed on that.
My lord, may I proceed?
Yes, sir.
My lord, only to recapitulate, there was a physical stock taking done in my factory, and in that stock taking, shortage of 341 metric ton of MS billet was found.
So the point, if I correctly remember, the point is very short. That there was a audit taking exercise by the
Physical
inspection,
stock.
whatever. Anyhow, for the purpose of finding out whether whatever you have submitted in your return is correct or not, and it was found that there has been a shortfall, and this shortfall they have initiated a proceeding and they call it a confiscation.
Confiscation.
And imposed. You say that confiscation can only be done on a physical goods. It cannot be done when it is artificial or it is non-existent. So this confiscation has to be understood in that perspective. If I correctly remember, that is what your argument was.
My lord, let me
Now
rephrase.
tell us.
My lord, let me refresh your lordship. My precise argument is that goods under section 130, subsection 2, 3, 4, 5, 6, 7, the goods is to be confiscated and to be vested in the government. The title will pass to the government, and the officer can give an option to the assessee to pay redemption fine in lieu of the confiscation and take back the goods. My argument was that when the goods are not available, it cannot be confiscated, title cannot pass to the government. Once I pay redemption fine, as I have done in this case, then the goods must be returned to me. When the goods are not available, it cannot be confiscated, title cannot pass to the government.
Sir, under the GST Act, you are supposed to disclose whatever the transaction which attracts the imposition of the GST. If you do certain things, that you manufacture a goods or deal with a goods which attracts a GST and sell it without any invoice having raised in this regard, or without charging the GST and depositing with the government, then in that event, what to do? Then according to you, what the government should do?
Government has,
because you have already sold, whereabout the goods are not known to anybody.
They have started two proceedings. One for confiscation, another for recovery of tax, interest, and penalty. Kindly see that, my lord. Kindly see that.
Please.
That proceeding, I am not challenging before lordship. I am contesting before the department.
Okay.
In that proceeding, they have demanded tax from me on the goods sought found, interest, and penalty. Kindly see, my lord, page.
Yes. Page
105, annexure 6.
Yes.
Kindly turn to my lord, page 110. This is another so-called notice, which is not before your lordship, which I am contesting before the department. Kindly see, my lord, the second table, finished goods, finished products in metric ton. Billet.
No, it is on three grounds. One is claiming the input tax credit against any transaction with a non-existent taxpayer. Second one is the short payment.
One of the ground is the shortage. Kindly say 110, my lord.
I could not get it. Can you repeat?
Kindly see, my lord, 110.
Yes.
There are two proceedings they have initiated. One for confiscation and another for demanding tax, interest, and penalty.
Correct.
Now I am referring to your lordship, the other so-called notice, in which they are demanding from me tax, interest, and penalty.
Yes.
Kindly come to page 110.
Yes.
It is not that the goods were found short and the state is remediless. They have done it.
Yes.
Kindly see, my lord, page 110, second table.
Yes, there is a shortfall of 341.360.
That is the case.
Yes.
In that case also, this quantity they have confiscated. This quantity they have confiscated.
Yes.
Now kindly see, my lord, the next page. If your lordship could kindly see page 111, serial number A.
Yes.
stock discrepancy finished goods MS billet. The taxpayer company was fined to the tune of 79,87,000, so much, and imposed penalty of 27 lakh, that is the breakup is there, altogether to the tune of 1 crore 7 lakh, that is 53 lakh, and this breakup, my lord. Under section 130 of the GST Act, pertaining to the unaccounted less stock of quantity of 341 metric ton valued at so much. Further, it is ascertained from the stock of MS billet is less deducted in comparison to the book account. There must be the outward supplies of those unaccounted stocks, less stock of MS billet to the parties, and the requisite tax has been collected by the taxpayer, but the taxpayer had not deposited the certain tax liability to the tune of 27 lakh, so much breakup. Category pertaining to the unaccounted less stock of the valued at rupees 1 crore 53 lakh. On confrontation the proprietor regarding the aforesaid query, he has neither offered any plausible explanation nor has any supporting documentary evidence near him to produce before the investigating officials that for the reasons described by Supra, the taxpayer company has deposited the penalty of so much and 79 lakhs towards the fine, but has not deposited tax liability amounting to 27 lakh, 13 lakh, and so on and so. Category which is required to be paid by the taxpayer company. Now can I turn to my lord, page number. Page number, my lord, 118.
100 and
118.
yes.
Last para, my lord, para 8. Accordingly, you are so caused as to why the amount as specified in the notice in Form DRC 01 under section 74(1) of the OGST Act, the calculation sheet is to ascertain to the of tax interest is mentioned in the following table based on the discussion made above in reference to the above mentioned issue under point number 4. Now kindly see the table, my lord. Stock discrepancy of finished goods so and so. Tax now demanded from me is 27 lakh. Interest demanded from me is 7,90,000. Penalty they say I have paid. Apart from that, other issues are also in the SOCAS notice. So my point is that the state is not remediless. They have issued me a SOCAS notice. The goods found short. Duty is demanded on me, from me on that, along with interest and penalty. So that is separate proceeding, not before your lordship. The thing is that when the goods is found short, tax can be demanded from me, interest can be demanded from me, penalty can be demanded from me, but confiscation cannot be done. That is my specific issue. My submission is only specific on this point.
Yes.
So on
That's
this
what I said. Yes. So that is what it says that that you wanted to say when it is a non-existent goods, can it be confiscated?
That is my point.
Yes.
Tax can be demanded. Tax
Yes.
can be demanded.
Yes,
Interest
yes.
can be demanded. Penalty can be imposed.
Yes.
But cannot be confiscated.
Anything you want to rely in support thereof?
My lord, one compilation I will hand over lordship. My colleague is
Where
there
is
in the
that?
court. My colleague is there in the court, my lord.
Yes.
Kindly see, my lord. Judgment of the Honorable Bombay High Court, where the concept of redemption fine and confiscation, the court had the occasion to deal with. My lord,
Which
it
one?
is page 24. Page 24 it starts, my lord. The page 24, SLP has been dismissed against that order, and we are concerned with page number, my lord, 26. 26. Judgment of Bombay High Court in the case of Commissioner of Customs, Finesse Creation Inc. Para 5, my lord. My lord, shall I read it? Page
Yes.
26.
1 minute.
Para 5.
So that was under the Customs Act.
The language of Customs Act and that of the GST Act is parametric. And the concept of confiscation and redemption fine under
Yes.
the law is one and same.
Yes. Yes.
Under the law is one and same. In all
Yes.
the law. In all the law, not only
No,
Customs
no,
and
I
excise.
understand. These are all the fiscal laws.
Fiscal law, that's right, my lord.
That's the interpretation has to be done in this way.
That's way, my lord. My
Yes.
lord, should I read the para 5 and 6?
I have already read, sir. You want to highlight anything? You can
Para
do.
5 and 6, these two are very important, my lord.
Yes.
They are the concept of confiscation and redemption.
Only when the goods are available. This is what
Goods
is
are available.
available.
Now, kindly see, my lord, the judgment of the Peace High Court. That is on page number, my lord, 32.
Yes.
Page number 32, Raja impacts. It starts, my lord. Kindly see, my lord. Page 33. Para 12 at the bottom and 13, my lord.
Yes.
My lord, kindly turn to page 35.
35.
Karnataka High Court, my lord. GM exports.
GM exports.
My lord. Para 2 is the fact where the goods were not available. And the conclusion is in para 4.
Yes.
My lord, kindly turn to page 28.
Back.
Back, my lord, kindly, my lord. Judgment of the tribunal, Chico Export, judgment of the tribunal has been upheld by the Supreme Court by dismissing civil appeal. Page 27, civil appeal is dismissed. So there is a merger.
Where?
Page 27, civil appeal is dismissed, my lord.
No. Page 27 is something. Just one minute.
Supreme Court ordered dismissing appeal, civil appeal against Chico Exports. Chinko Exports.
No. Chinko export judgment starts from page 28.
Yes, page 27 is Supreme Court judgment order dismissing civil appeal against the Chinko Export. So civil appeal dismissed, so it is a merger.
No,
So my lord, kindly see now.
Just 1 minute. Just 1 minute. Was it a simpliciter dismissal or a dismissal with certain findings?
No, my lord, I would say it is dismissal simpliciter of civil appeal. Civil appeal. Civil appeal.
Without recording
So
any reasons? Without recording any reasons or recording a reasons?
Civil appeal without dismissal, dismissal simpliciter will merge. And not SLP. Civil appeal. Yes, my lord.
We are talking about the merger of an order.
That's right, my lord.
So we have to. Kumayuddin judgment of the Supreme Court is very, very clear on this. I think we have to read it, that judgment in that perspective.
But I have got with me, my lord. I will take your lordship with that also. In this comparison, it is there.
And the first judgment is of a Gojer brothers.
Kindly see, my lord, page 31.
Yes, Cohamet is 2000.
Page 31, para 10.
Page 47 is, it starts from page 30. No.
Yes, my lord.
36. It starts from page 36.
My lord, if I am not completed on the Chinko Export, my lord.
Yes.
Kindly see page 31, my lord.
30.
31, my lord.
Yes.
Para 10.
Yes.
My lord, kindly see page 18, my lord.
1-8.
1-8, my lord.
Yes.
Bombay High Court has upheld the judgment of larger bench of the tribunal, and while dismissing the appeal, kindly see, my lord, para 2, 3,
Yes.
para 2 and 3, my lord.
Para?
2 and 3, page 18.
Yes.
My lord, tribunal judgment that starts on page 19, the findings are on page 21, which is upheld by the Bombay High Court. Page 21, para 9, 10. In Western components,
Page.
137, my lord.
So the power to levy the redemption fine is still there with the authority, but not the confiscation.
No, my lord. Confiscation and redemption fine is one and same. Confiscate.
What this
and
judgment
give me
says.
an option. Give me an option to pay the redemption fine, take back the goods. So if it cannot be confiscated, no redemption fine can be imposed. What the judgment says, that if the goods are released, suppose, my lord, what I have been contending all along, that goods are not available.
No,
but
why you are referring page 137? Please read
I am
that.
only to throw a light on the point that
What it says, this judgment containing 6 sentences, what it says.
My lord, when the goods are released under bond,
Yes.
goods are seized. Means goods were available and seized and confiscated. I gave a
That is what
bond.
the court says, that it did not, even a release is done on a basis of a bond. It does not really take away the power of the authorities to impose the redemption fine.
No, my lord, it's only
Please
says.
read that. Under the circumstances, may I read for you, third line. Under these circumstances, if subsequently it is found that the import was not valid, or that there was any irregularity which would entitle the custom authorities to confiscate the said goods, then the mere fact that the goods were released on bond being executed
Bond
would not take away the power of the authorities to impose the redemption.
I am on that, my lord. I say if the goods are physically found, seized,
that you want to draw an analogy. You are really trying to draw an analogy that
yes,
it was available, even if it is released, there is no difficulty. But if it is not available, no power.
And released. Seized and released. My lord, in the GST rules, my lord, in the GST rules, kindly see rule 140, my lord. CGST rules 140.
140.
140, my lord. My lord, may I read it?
This is the power to release the goods on a provisional basis.
That's right, my lord. Had the good been seized,
yes,
and released on
bond, you are really trying to draw an analogy that whatever the judgment that has come up, it says that there was an availability of the goods
That's right.
Confiscation could have been made. And if those goods were subsequently released, maybe on a provisional basis, or maybe on the basis of a bond, or on the basis of an undertaking being given by the SSE, then in the latter part, if it is found that this was not
Yes.
valid, then in
Yes.
that event, there is no difficulty on the part of the authorities
Correct.
to impose redemption fines.
Correct.
Is your contention?
This is my contention. So, my lord,
Here you want to say that there was not a trace of any goods being present or being in existence, and it was simply a case of a shortfall. So
That's
the
right.
question of confiscation cannot arise at all.
That's
because
right,
the
my lord.
goods are not physically available.
That's correct. That is my whole submission, my lord. My lord, in the compilation, just I will not take much time, my lord. In the compilation, one judgment, it just had heavy index, my lord. In the index, just I am indicating, my lord.
Yes.
Serial number 7, it deals with that Kunaya Ahmad,
That's true.
there or not. It is there, my lord.
Correct.
8 and 9, it says that no taxes shall be levied or collected by consent of the parties, but by statutory, by the authority of law only. Then, my lord, serial number 10 says, then taxing statute are to be read strictly.
Correct.
Nothing is to be implied, nothing is to be borrowed from here and there. One has to look at the statute only. That is on 10, my
The
lord.
principle is that a literal interpretation is to be followed, not a purposive construction.
Purposive construction.
Yes.
Serial number 11, my lord, Kalabharti, it says, sublato fundamento cadit opus. When the foundation goes, the superstructure will fall.
But there is a reverse also.
My lord,
The maxim is reversed also.
in my case,
When you use this, there is a reverse maxim as well.
my lord, in my case, I say the so-called noted itself without jurisdiction. So the whole structure will fall.
Yes.
My lord, then my lord, 12 and 13, it says that illegality of jurisdiction, wherever it is found, whether in the same proceeding or collateral proceeding, it can be set up as a defense at any stage. That 12 and 13 says that, my lord.
Okay.
Then, my lord, 14, my lord had raised a question.
You're talking about the Kiran Singh's judgment. The Kiran Singh's judgment is founded upon when there is a order passed by a court lacking inherent jurisdiction. Then in that event, such order would per se be a nullity, and the
That's
nullity can be assailed in collateral proceedings as well.
As well.
There is no difficulty. Kiran Singh's is very clear in those times and is still following.
My lord.
Lack of complete jurisdiction, nothing more than that.
Correct, my lord.
Yes. Then,
My lord, 14 and 15 is on maintenance of your writ against a so-called notice. Though here I have come against your order, but I say, if you say that is so-called notice, if the so-called notice is completely without jurisdiction or issued in the abuse of power of law, it will be maintainable. It is on that too, my lord. That 14 and 15.
yes.
That these are judgments I am relying, my lord.
Yes.
My lord, from my side, my lord, if you would permit, I can give a small written notes. By tomorrow.
Do you think it is required, or we will not take?
I will make a small gist for my lord's convenience, one.
No, there is no difficulty.
My lord.
If you chose, you can give. There is no.
It will be handy, my lord. It will be handy only.
There is no difficulty. You can give a bullet points. You can give it whatever, but still, I vividly remember what you have argued.
My lord is correct.
The point is very small and short.
Correct, my lord.
Yeah, whatever. Yes, let us. That's all.
That's all, my lord. That's all.
Since the facts are very much clear here, Your Lordship.
Correct.
And on the last occasion, I have placed the
judgment of Gujarat High Court.
Adjudication order, Your Lordship.
Okay.
So I may not require to go to the adjudication order and
Correct.
facts of the case, Your Lordship. So far as the legal issue is concerned, Your Lordship, I may draw Your Lordship's attention for a movement, section 130. Your
Yes.
Lordship, for a movement, it is for
Yes.
Your Lordship. Section 130.
Yes.
Confiscation of goods or conveyance and levy of penalty.
Correct.
Your Lordship, where any person any person supplies, your lordship may give emphasis to the word supplies. Obviously, supplies means the goods are not available. That must have been supplied. Supplies or receipts any goods, your lordship, of any goods in contravention of any of the provision of that. 2 is does not account for any goods which he is liable to pay tax under this act. 4, your lordship, 3, your lordship may escape. 4, contravenes any of the provisions of the act and the rules made thereunder with intent. 5, your lordship may escape. Then all such goods or conveyance shall be liable to confiscation and the person shall be liable to penalty under section 122. Your lordship, for a moment may kindly turn to 122. He shall be liable to pay a penalty at 10,000 or a he shall be liable to pay a penalty at 10,000 or an amount equivalent to tax evaded or the tax not deducted under section 51 or shall deducted. Your lordship, this is the quantum of penalty. So they are, as per this provision under section 131, read with 122.1, your lordship, the penalty has been levied, your lordship. So what I think, there is no dispute. So but the 2 is the dispute. 2 is your lordship. 2, your lordship, whenever confiscation of any goods or conveyance is authorized by this act. Your lordship may kindly pause for a moment. Authorized by this act. Here, your lordship, 2. 1 is penalty.
I
2 is fine, your lordship. Whenever confiscation of any goods or conveyance is authorized by this act, why I am showing, I'll go to that question mark, your lordship. Authorized by this act. So there must be authorization. Your lordship, pause for a moment. May kindly turn to section 67. Pursuant to which the inspection has been made, authorization has been issued for confiscation.
Yes.
Section 67, your lordship.
Power and inspection, search and seizure.
Search and seizure.
Yes.
When the proper officer not below the rank of joint commissioner, your lordship, here
He has not raised those issues so far as the inspection part is concerned. He has not raised.
I'm going to do
Yes.
authorization. When the proper officer not below the rank of joint commissioner, either pursuant to an inspection carried out under subsection 1 otherwise, he has reason to believe that any liable to confiscation. Your lordship may kindly emphasize the language liable to.
Correct.
Not particularly the goods available, liable to confiscation or any documents, not only goods, any documents or books or things which his opinion shall be useful and relevant for to any proceeding under this act. Your lordship, basing on this authorization, your lordship, confiscation has been made. Now, your lordship, without wasting your lordship valuable time, the Gujarat High Court judgment, your lordship, the portion, relevant portion, I may be permitted to play, and all of my lawyer here are cited. All those have been taken into consideration, and some of the judgments have been reversed, your lordship. Your lordship may kindly turn to directly page 93, paragraph 165.
Yes.
Page paragraph 165.
Yes.
We shall now proceed to deal with the last submission as regards the physical liability.
Availability.
Sorry, physical availability of the goods and purpose of redemption of time. This submission has been canvassed by PM Dhave, the learning counsel appearing for the writ applicants of the special civil application number so and so. The argument of Mr. Dhave is that concept of redemption fine is embodied in section 130 of the Act. Even while ordering confiscation, the officer concerned has to keep the owner of the goods an option to pay so and so. It is submitted that concept of redemption fine arises or goods are available and have to be redeemed. If the goods are not available, there is no question of redemption of the goods. This is the argument. Then to Mr. Dhave, once goods are released upon the payment of
So he has relied upon a finesse, then Raja impacts.
Your lordship. And also Supreme Court Western. Later on, your lordship will find out the Western Supreme Court.
Finesse has been considered in the latter portion.
Your lordship, the latter portion, everything has been considered. Your lordship may kindly turn to 170. These judgments have been considered. 169, 168, your lordship. That's 95. The principle discernible from the aforesaid two decisions that The redemption cannot be imposed if the goods are not available. Redemption can be imposed provided the goods are handed over to the owner upon execution of any bond undertaking. This is the essence. In the Supreme Court decision, the goods were released on execution of bond. However, later when the goods became liable confiscation, the goods were available. It has been held by the power of custom authorities confiscate. That Western, your lordship, so far as that Western. Fine is not taken away merely because the goods are essential, your lordship. Your lordship, just above the paragraph, the Western components, your lordship, the Honorable Supreme Court judgment has been taken into consideration. Got it, your lordship? Just above paragraph. Now, your lordship, also 170, paragraph 170. At this stage, we must look into the decision of Supreme Court in case of Western component commissioner versus commissioner of custom. Your lordship, the paragraph has been quoted. We are not impressed with the aforesaid submission.
That is what I.
As regards to your lordship.
That is what I also invited his attention.
I'll place your lordship.
Yes.
With the aforesaid submission as regards the redemption of fine in the absence of any goods.
No, that I have already read.
Your lordship. Your lordship may kindly turn to 170. Then 130 subsection 2 has been taken into consideration. 173, what is the meaning of redemption?
Yes.
Your lordship. Then 174, the prerequisite for making an offer. That is, your lordship. Section 130 is pursuant to the finding of the goods are liable to confiscate it. In other words, if there is no authorization for confiscation of such good, the question of making an offer by proper official redemption would not arise. Therefore, the basic premise upon the citadel of section 130 are liable to be under the Act. It follows of what is sought to be offered to be redeemed are goods, but not the improper conduct of the owner. We must also bear in mind the owner of the goods is liable.
It says that if his conduct and the act is such which would render the goods liable to be confiscated, then in that event.
Exactly. Your lordship, when your lordship, paragraph 175.
Yeah.
The dictum of Madras High Court. Your lordship, I may be permitted to Madras High Court judgment also. We would like to follow the dictum as laid down by Madras High Court in 23 refer to above. We may also refer to Honorable Supreme Court MG abroad. Your lordship, after this paragraph 23 of Madras High Court judgment as 174. We would like to follow the dictum.
The difficulty is, sir, you are downloading from a particular site who does not ensure that all what is typed there is correct. I find lot of spelling mistakes in this judgment. That is not possible in the original judgment.
Lordship, I will submit the original judgment.
Is very difficult.
Your lordship.
You are trying to make us rely upon this. It's very difficult, sir. How can we quote the paragraph which is defective one? It might have been reported somewhere.
Your lordship, that has been reported.
And now it is a neutral citation is also available.
Your lordship, AIR online 2019 Gujarat.
So that is the most authenticated.
Your lordship, I'm sorry. I'm very sorry. Your lordship, the matter honorable.
What is the citation? AIR?
That is in the upper head. AIR online 2019. That is in the first page of the judgment. Equivalent citation, your lordship.
Oh.
Your lordship, answer.
Yes.
So my respectful submission before your lordship is that what is the Honorable Madras High Court? Honorable Madras High Court, your lordship, so far as the custom act, your lordship, the identical language. Two provisions are there in the custom act. 111 is the authorization. 125 is equal to 130 subsection 2, which has been quoted. Your lordship, the language is very much same. The 125.
So you say that this is really a parametria with.
Yes. Your lordship, so far as 130 subsection.
Correct.
125 of the custom is the parametria provision.
Correct.
So goods are not required to be available for confiscation, your lordship, and redemption of fine.
Correct.
So, redemption of fine. Now, your lordship, since the law is very clear, your lordship, Honorable Gujarat High Court, even Honorable Gujarat High Court has not decided to case basis. Your Lordship, from the very beginning, if Your Lordship will go to that judgment, if Your Lordship will allow me, permit me, then I will place some paragraph.
So this is really an authoritative judgment where the point of law is discussed and decided.
Then sent to the taxation bench to decide case by case. There are only 120. And another thing, Your Lordship, so far as 73, 74, and so far as 129, 73, 74. Our Honorable Gujarat High Court has said all these provisions are different. No provision is depending with other.
So according to you, these are standalone provisions? And not dependent upon any other.
Your Lordship. Now, Your Lordship, so far as the second argument of my learned senior, that 74 is the appropriate provision, and for that reason, 74, the tax and interest has been demanded since penalty has been paid. Your Lordship may kindly again 130. There was an amendment. Your Lordship, section 130, that was before Your Lordship, before 2021.
Yes.
There was the section 130.
So that subsection 3 you want to.
No, Your Lordship, section 130, subsection 3. Your Lordship, sorry, I'm sorry.
So move fast with me. Move fast with me.
I bow down, Your Lordship.
So it was where any fine in lieu of a confiscation of the goods is imposed under subsection 2, the owner of such goods or person referred to shall in addition be liable to pay tax, penalty, charges payable in respect of such goods.
This tax
has been omitted.
This tax has been omitted. Only penalty and fine was there.
Correct.
For that reason, Your Lordship, for levy of tax, 74 has been initiated and no penalty has been levied because penalty has already been paid, Your Lordship.
Correct.
So penalty has not. So it is a separate proceeding, Your Lordship, and it has not been challenged here also. And so far as the next question, Your Lordship, it may be academic, Your Lordship. So far as Your Lordship has already gone to Annex 4, where he has admitted, where after issuance notice he has admitted and paid the penalty and fine, and pursuant to his admission, the order has been passed, Your Lordship. And Your Lordship, GST law has been framed in such a way, Your Lordship, may kindly 75 code, all other provisions, Your Lordship. Once you admit and you pay the tax penalty, your tax interest and penalty, Your Lordship, and all the proceedings subsequently start there, close there, Your Lordship. And regarding this one judgment of this Honorable High Court, Your Lordship, I may be permitted to place one judgment. This Honorable High Court has categorically held. Your Lordship, here the notice has been issued, and after notice the payment has been made. Your Lordship may kindly turn to paragraph 5. The second page, paragraph 5, it is a small judgment. At this juncture, it is necessary to note that Rule 142(1)(a)(2)(a) of the GST rule, it is open to the person against whom the demand is raised to make partial payment and also to file any submission against the proposed liability. In part PDRC 01A, the petitioner did not opt for the above procedure. Instead, the full payment of the tax demanded by the department without any protest. It is only 3 months after making such payment, he has choose to write a letter disclaiming any liability and neither saying that earlier payment was made under protest nor demanding refund of payment so made. Now, Your Lordship may kindly the quoted paragraph. As you have paid the amount of tax, last 4 line, as you have paid the amount of tax and other dues, along with applicable interest in accordance with the proceeding initiated by the said notice.
The notices are hereby concluded.
Your Lordship. And next paragraph, if the petitioner wanted to contest the demand, he ought to have adopted the procedure already outlined under Rule 132(1)(f). For the reason thus he did not opt for the procedure, also till date.
So according to you, here also there was no action.
Submission before Your Lordship is that this order has been passed, Your Lordship, basing on the concession on 29 March 2023. Your Lordship, after lapse of 2 years, 2 years he became silent. Your Lordship may kindly look into the conduct of the petition. 2 years he became silent, and all of a sudden he challenged in by saying that it has been uploaded in the portal. It is not well within my knowledge. So I have not filed any appeal. So my appeal may be admitted. But since 169(1)(d) is a valid service Your Lordship has already held, so But it is a valid service and it is well within the knowledge of the petitioner. Hence, the appeal has been dismissed on the ground of delay. And at this stage, Your Lordship, he is going to challenge the show cause notice, which has been complied. Your Lordship, for a moment, may kindly turn to section 160 for a moment. He is precluded. Your Lordship, section 160 clearly says, assessment proceedings are not to be invalid on certain grounds. Your Lordship, one may not be, no assessment, no reassessment, adjudication, review, revision, appeal, rectification, notice, summon, other proceeding done, accepted, made, issued, initiated or purported to have been done, accepted, made, issued, any of the provision of shall be invalid or deemed to be invalid merely by reason of a mistake, defect, omission. Your Lordship may kindly work too. The service of any notice, order or communication shall not be called in question if the notice, order, communication as the case may be has already been acted upon by the person to whom issued where such service has not been called upon in question or earlier proceeding.
Based on doctrine of acquisition.
Exactly, man.
Acquisitions.
Fully. That is my submission. All and a sudden, why Your Lordship? Because GST law, Your Lordship may kindly, in all this, Gujarat High Court has also said, GST law has framed, Your Lordship, one paragraph, last paragraph, Your Lordship may kindly go into the last paragraph of that.
What it says so?
Your Lordship,
We have already read.
Your Lordship, that in that judgment has said the last beautifully, Your Lordship. Your Lordship, as court of law, we can only urge the assessee to keep their transaction fair and transparent. If the transactions are fair and transparent, there should be no room for any complaint. At the same time, I expect GST authority to ensure no undue harassment. The GST authority should try to understand the various execution and implementation of the law. The new tax regime in the country over a period of time will prove an effective one. And with the passage of time, the proper implementation of the provision, the difficulties which the assessee are facing to minimum. All that we intend to say is in a given situation, the authorities should adopt a practical approach. Your Lordship, and litigation arising the new target minimized over a period of time. So
Balancing the interest of both the SSC and the taxing authority.
intention here is to minimize, Your Lordship, the minimize litigation, Your Lordship. For that reason also, all the provision, Your Lordship, 75, 107, all the provisions have been instituted in such a way that to reduce the litigation, Your Lordship.
Yes. Would you like also to file some short notes?
Your Lordship, Your Lordship,
No. I at least myself and my brother may not, but it is up to your satisfaction. As the counsel for the appellate petitioner says that you want to file. So that's why.
My lord, allow me 2 minutes time to rejoin.
Yes. You are in reply. You have a right, but only on a proposition of law, sir.
No, here and there.
Yes.
My friend said, I acquiesced.
Yes.
Law says, when I pay certain amount as my admission, then they have to give me an acknowledgement in form DRC 04 under rule 142, 2 and 3.
Yes.
And then they have to issue another declaration to me in form DRC 05, conclusion of proceeding. Now they have not issued the acknowledgement of my payment in DRC 04 and they have not issued conclusion of proceeding in DRC 05. I am referring to such rule 142, 2, 3 and 4.
Yes.
This is my only submission that I want to edit. And my lord, my friend has rightly said one thing, that in section 130, there are two parts. One part is 131, which talks about penalty, and the condition is liability to confiscation.
Correct.
For penalty, liability to confiscation is enough.
Correct.
I am at one with him. For the second part, confiscation per se and redemption fine, the existence of good is a must. Liability is not the condition there, but the existence of the goods.
Correct.
That's all the submission is, my lord.
Yes, thank you. So how should reply to a reply? What? You give your submissions?
On 27th, he has requested to pass an order so that we will make payment. On 29, we have passed the order.
Indicate that. Verify both of you.
Day after tomorrow.
Yes.
My lord,
Day after tomorrow.
day after tomorrow, my lord. I will file it.
The parties already concluded their submissions and praise for a direction to file a short notes of argument. Let short notes of argument be filed on Wednesday. Give a date. Wednesday will do.
Wednesday, my lord.
Thursday,
My lord, no further hearing.
by Thursday. Because I have to.
My lord,
Because I have to take.
no further hearing, my lord.
On Wednesday.
No further hearing, my lord.
List the matter on that day for submission of the written notes of argument. Yes.
My lord, no further
An
argument.
interesting point, definitely. That give me a good food for thought.
My lord, deeply obliged, my lord. Grateful.
I'm grateful for your specific hearing.
In this matter, I have already given consent, my lord. Now our name should be deleted.
Item 2.
Yes. So,
What is
Item 2 is saying that.
sending us one.
You are appearing.
No. We have.
Now you are appearing.
Our name.
So you argue.
I am now attending.
Yes, argue.
Highlight your name.
We are releasing her. She has already given a no objection in your favor. So you are a newly engaged lawyer.
Already in this case, state has not got the copy. Copy may be given.
Copy and sir. Next week.
The office said it is not. I will verify.
What is your name? What's your name?
Priyanka.
Ms. P. Jena, and I'm counsel for the appellant who appears for the petitioner. Seeks time to serve a copy of the appeal on London State Council. I'm learning the main advocate. Next week,
Yes, sir.
based on 21st April, actually.
Item number 3.
Well, I don't feel the petitioner as a practicing advocate for more than 50 years.
Yes, there is already, sir, what the authority is, there has been a judgment saying that so far as the legal professionals are concerned, they are not coming within the regime of the GST. Then why continuously we have experienced at least 4 cases here when the decision has already been taken? Why?
The fact remains not. Each thing there is not within knowledge, it depends whether he is a lawyer or whatever profession, properly finally done. And we don't know whether he is a lawyer or any other profession. So I have filed a counter in Lordship C.
Order sitting with the
Yes, I am not disputing. I am absolutely.
There are 2 orders. One was another was final by his lordship.
What I am submitting, Lord.
So we are quashing it, making it because we find from his income tax return there's a income from the profession
yes.
and the income from a house properties. So both are outside the purview of the GST.
No. Rental is within purview of the system. It is not GST, it is Finance Act. It is not GST.
Okay, Finance Act.
So it is come within the purview of the taxation law. So far as the Finance Act is concerned.
No, that is under the Income Tax Act. So far as the GST is what I am talking about.
We are not here in GST. We are in the Finance Act.
This is the GST.
It is service tax.
Yes, service tax. Sorry, I stand corrected. Service tax. Yes.
So your lordship last order directed me whether the order has been passed in midst of the hearing. But the order has been passed below 9/8/2024. I've already filed a counter to that. What I suggest your lordship previously passed an order because of ex parte order, in spite of submission notice in mail, everything, your lordship redirect that he has appeared.
And he will appear and give all the documents relating to your profession.
Yes, that is what I.
You have claimed 50 years of practice. Submit the document.
Yes, that is good.
But he has, why don't you do one thing? Because he has included or annexed all the documents pertaining to his profession. So those can be taken into account. He has produced this page 9.
Yes.
The member of.
Correct, Millard. No, Millard, I absolutely correct. But in addition to that, Millard has filed an audit report wherein he has himself means he has collected some rent, and rent is within the purview of the Finance Act. And if it is come within this within the limit, then he may exempt it.
No, we are not on the rent.
Rent, he has rent. Actually, I have seen the income from the house property.
Yes.
I do not know.
Does come under the purview of Finance Act. What I say, if it is going to come within the purview of the limitation, I mean the limit of registration, then also is exempted. Then also is exempted. People also see my counter I filed on 5th.
Income from the house property. At the top. After that, so 4,80,000 has the estimated deductions. So he has. And so. The only I would say taxing provision is regarding that. Profession, definitely not. No. Had it been a income on profession, no problem. But you have shown the sizable amount of house income from the house property. Is an agricultural income?
Rent income.
Or rent income?
No, you are the councillor, you must be knowing.
Explain before the authority.
Yes, that is that.
The professional part has to be this.
Definitely.
It will not come. Then you have passed the audit.
Let's see, I have
Matter.
already filed counter.
But counter is not some under.
I keep that file. I have already started the possibility. When taken reference, pass the order directing to appear on such and such, he may.
I'll pass the order. Give me the file. I'll pass the order.
There's your order at least 26.
Not say fix up a date so that he can appear.
I'll pass it.
Yes. And the second order is at page 30. You have completed it.
Next.
Item number 4.
In this item, I got some more time to file. We have received the paradise comment will be filing within a week.
It's a case of illegal adjustment of refund against demand which has already been stayed. On the last.
What does it mean? I do not know. If it is a state, then what does it mean? It is paused and set aside.
Yeah.
It is yet to be tested. It may either go in your favor, it may go against you. Then if suppose the court goes against you and lifted the stay order, upholding the contention of the department, then what will happen?
They can always recover money.
Anyhow, what he wants a parawise.
We have already received the paradise comment within a week. We'll file 2 weeks time.
All right, Mr. Manti, you are Mr.
Avinash Kid.
So he KDL and standing council.
Junior
standing council. 6 counter within a week. List on 23rd. At least. So waiting for the application.
Item 5.
So it's Mr. Maria will appear to receive.
My lord, may I be permitted to appear online, my lord? My lord, am I audible?
Yes.
Yes, sir.
My lord, may I start, my lord?
Yes.
My lord, this case pertains to my lord GST Act, my lord.
Yes.
The main dispute in this, my lord, the main issue, whether in this case, my lord, under which section the so-cause notice and adjudication order to be passed, whether under section 73 or under section 70.
Yes.
Now, my lord, there is basically the difference between section 73 and 74. There is no difference of tax rate or, my lord, interest component. Only difference is, my lord, penalty. The rate of penalty, my lord. In case of 73, it is 10%, and in case of 74, it is 100% penalty, my lord.
Yes.
Now, my lord, on 73 and 74, my lord, in case of 74, the department is required to prove that the short payment of tax or excess availment of ITC is made due to the reasons of fraud, willful misstatement, or suppression of fact, my lord. The department is
With an intent to evade tax.
Yes, my lord, and that is my intention. Intentionally, I have evaded, my lord. This is, my lord, requirement. The department has to prove, my lord. My lord, what happened in this case, my lord? There was an investigation against 5 suppliers of mine. Now, my lord, after investigation of my suppliers, they found that they were non-existent. Their registration was cancelled, my lord. No. Registration was cancelled, my lord. My lord, in
Prior to transaction or after the transaction?
after the transaction, my lord. After the transaction, my lord.
Yes.
In all the 5 cases, my lord, they have cancelled registration. They have given the effective date of cancellation. In all 5 cases, my lord, after the date of transaction.
Yes.
Now, my lord, my humble submission is that, my lord, to disallow my IT purchasing from those selling dealers, my lord, for disallowance my ITC, department has to, my lord, bring any evidence that I have any connivance with those sellers, my lord. In this case, my lord, the department's finding is that since they are not in existence, therefore my purchases are not genuine, my lord.
You are appearing for whom?
I am appearing to state GST.
I am appealing for the central GST.
My lord,
Both are alter ego of each other.
He is the answering party. We have
It does not attract the state GST. So why is an answering authority?
No, why
You want your component
his order
to be given to you, and he wants his component to be given to.
His order has been challenged.
So whatever.
On the ground,
Beneficiary is you also.
Obviously. On the
This very interesting point, which struck my mind. The interesting point is when a transaction was ensued, at that point of time, the person from whom he purchased the goods, he was a registered supplier. He had a GST number. He paid the GST to him as a bona fide purchaser. Now, subsequently, that was cancelled so far as the suppliers is concerned. Now, since he has paid the GST and then onward he has collected the GST, he is required to claim an input. Input credit he is entitled. So he has claimed an input credit. But you say that since his registration, the supplier who have collected the GST from you, that registration was cancelled. You will not be permitted to claim any inputs. Input credit means, that is what I understood. Maybe wrong, maybe right, I do not know. How he will be liable? At the time of transaction, there was no difficulty.
There are certain precondition. As per section 16. Under what circumstances the purchaser can have the benefit of input tax credit. There is not only the not only the restriction that as he has paid the tax to the supplier, the tax invoice is there, and basing on that, the input tax credit cannot be allowed. Your Lordship, as per the provision of Section 16. Section 16 gives some certain conditions that there must be tax must have been paid, Your Lordship. There must be a tax invoice. There must be movement of the goods, Your Lordship, and the tax has been deposited in the government.
Suppose I'm going, please, as a good student, I'm just putting certain questions. Suppose what happened that I have paid the GST to a supplier who is definitely a registered one. Now, suppose there are two conditions. One is the cancellation. Second one is that despite collecting the tax, he did not deposit with the authority, with the revenue authority. There are two contingencies that may come from him. Suppose, let us see in both the cases, suppose he did not deposit. You say that the first of the foremost condition is that he must deposit with the department. Then you can only claim the input credit. Otherwise, you can't. Suppose not deposit. You can initiate a proceeding against him for evasion of the tax. Against him, not against him. You can impose, against the supplier who defaulted in payment of the tax after collecting the tax. Consider, collected the GST but did not deposit. You can initiate a proceeding. Evasion of a tax. You can impose tax liability. You can impose penalty. You can impose an interest on him. Suppose if he pays later on. You have denied it now.
I have kept.
Then what is his remedy? A bona fide purchaser who have paid the GST, then what he will do?
I have kept all my arguments so far as to argue against the cases so far as the constitutional validity of Section 16(2)(c). But however, you let's say,
you recovered from them.
It is somehow impossible.
Let us see, there is a single supplier. Don't do it in this hypothetical case. You can't equate. Hypothetically, there must be only one supplier.
The owners under Section 155.
There are many manufacturing units, I tell you, where the raw materials are prepared or manufactured by a particular company. So there is only one source of supply. Right. Suppose if it is the position, I'm just asking this, how double benefit the department would get in this regard. Suppose if he's a supplier, he supplies the goods to the manufacturer, the purchaser. He has charged GST because that attracts GST. And then the purchaser has paid the GST, purchased the goods, utilized the goods, and then sold it in the market. The finished good also invites the GST. He collects the GST from the different source of his purchasers. Now, he is entitled to an input credit. Now it appears that supplier did not deposit the GST amount which he collected from the purchaser. Suppose. And now he is not at fault. Now then, the department can initiate a proceeding against the supplier for evasion of the tax under Section 73 or 74, whatever, that you have failed, you have evaded the tax. Then department is also saying that you, being a purchaser, may have paid a GST to the supplier, but since the supplier did not deposit the GST amount, you are not entitled to an input credit. So you denied that input credit to the purchaser. Now the purchaser has to deposit the entire GST which he collected from his purchasers of the finished goods. He has to deposit. Now what has happened? Now
Please, and
then what has happened? You have initiated a proceeding against the supplier, initial single supplier, and then you impose tax penalty, interest.
Your Lordship.
Now the proceeding may have taken 1 year, 2 year or 3 years go, because you know the hierarchical system of the adjudications.
Right.
After 4 years, say you collected the tax from that supplier with the tax, with the penalty. Now, this purchaser who has been denied that credit, can he avail retrospective?
Your Lordship, about
Yeah.
Your Lordship, only the owners, Your Lordship, as per income bill, Your Lordship, as section 70 of so far as the VAT Act is concerned. 155 is
I'm
owners.
giving you a very hypothetical example.
Yeah.
Consider this. What to do?
You'll now have to ready sufficiently to our constitutional validity matter, Your Lordship, as regards to 16(2)(c), Your Lordship.
Look at the jeopardy of the bona fide purchaser. Just imagine.
Your Lordship, for a moment, that 26 AS under Income Tax Act, why this has been
That's a TDS related. That I understand. 26
TDS has not been deposited.
Correct.
Your Lordship, you can put up
The difficulty is that if the TDS is not deposited,
take the credit.
you cannot. You'll have to pay the entire money.
Your Lordship.
Where is the corresponding provision for collection of the TDS?
Your Lordship, there is a penalty provision 201.
That is different.
Your Lordship.
Penalty and fine is a different.
Right.
That's an imposition.
Right.
But the collection of a tax in GST, you not only collect the tax, but also collect the penalty and fine and interest. So far as a component of penalty and interest is concerned, purchaser cannot get a benefit.
I bow down,
But
why-
so far as the tax collection is concerned,
Your Lordship, I bow down, but why this has been done? Your Lordship might have remembered, might have gone through. Through that GST fraud, Your Lordship. 100 crore, 200 crore, 300 crore, 1300 crore, 1400 crore. How this? Because of this. This,
no,
Your
I'm
Lordship,
just trying to understand,
Yeah.
figure out the situation like this. You are absolutely correct. One cannot be permitted to avail the ITC
particularly in this case.
unless the corresponding the contractor
Match.
or a person who has entered into a contract pays off. He can't get a credit. I understand. I was thinking in that line, that's in future if you collect the tax of that, then what would happen? What is a right? What is a right? Because he is not at fault. A purchaser cannot be said to be at fault.
In that case,
He has to suffer because of the fault of another with whom he had a bona fide transaction.
Already in that circumstances, there is a provision. I think that there will be the purchaser will get the credit. Your Lordship. 16(4), 16(5). Your
Just
Lordship.
show us that it
Your
can
Lordship,
get it retrospectively for that year.
16(4). Your Lordship, for a moment. Section 4.
Sure.
So for that reason, section 16(5) has been introduced.
Sure.
But,
I am also trying to understand.
Your Lordship,
Yes.
section 16(4),
Yes.
the disallowance once you will not file the return.
No.
The supplier has not filed.
Please, the registered person shall not be entitled to take an input tax credit in respect of any invoice or a debit note for supply of a goods or a services, or both after due date of furnishing the return.
Your Lordship.
Please, is battled after due date of furnishing the return under section 39
Your Lordship.
for the month of September following the end of financial year to which the invoice or date is earlier.
For
So
that
you have-
reason,
I'm just talking about
introduced a new provision, 16(5).
16.5 is
Your
not
Lordship.
here in my book.
Sorry.
It ends with 16.4.
Recently, in this year,
It ends with 16.4.
Your Lordship. 16(4), why a restriction was there.
Correct.
And by looking into that restriction, now the constitution has amended and the new provision has been introduced. Your Lordship, 16(5). Notwithstanding anything contained in subsection 4, in respect upon invoice or
No,
debit.
there is also a proviso inserted to 16.4. It was not there.
Provider as well as because for financial year 17, 18, 18, 19, 19, 20 and 2021, all these restrictions were there 16.4. Now they have relaxed that if the supplier has filed return by November 21, then all
Up
these
to
are.
November 21.
Your Lordship.
Suppose I'm talking about the future one.
Legislature, Parliament is looking into this, Your Lordship. Your Lordship, I'm bowed down, Your Lordship.
Yes,
restriction.
Yes, I understand.
But in this case, Your Lordship, we find out all the non-existent deal. No, what Your Lordship, what is to my mind, Your Lordship, also. What is the non-existent? Your Lordship, because all this fraudster, there is no actual business, Your Lordship. In the premises, there is no actual business.
File your
Only
affidavits.
paper transaction.
File your affidavits.
Your Lordship.
We can't stay at this stage, sir.
Yes, not.
My lord, I have paid the entire tax amount, my lord.
Yes, then.
My lord, I am paying only conversion of the so-called notice from section 74 to 73 only.
Already is agreed in 3 to 4 in the cases when he has paid tax, penalty, and interest also.
So,
and another 3 dealers, he has paid tax, and the penalty is also applicable in section 74 reverse.
So, the last day, Your Lordship might have has gone through this, and an advocate has submitted one circular that investigation 74 is the must, and this is basing on an investigation report, Your Lordship. So but there is prima facie case of 74, Your Lordship. So that it may not be converted, Your Lordship.
no, sir. You file your affidavits. That cannot be converted in this.
My lord, may I be permitted, my lord? My lord, I am led by Mr. Sandeep Churia. He wants to add something.
Extreme 40 minute, I was on another bench.
Yes.
If I be allowed, my lord.
Yes.
My lord, the fact of this case there is
Sir,
that
it has already been argued, sir. So we are at the stage of passing a direction, a very short affidavits. We are seeking within a week so that we can decide it, because
there is an amnesty scheme, my lord. There is an amnesty scheme, my lord, which I want to avail, my lord.
Amnesty
I paid the tax, I paid the interest.
73. But that is
that is what is saying. Amnesty, what it says is amnesty scheme is 73.
73.
And not in relation to 74.
Yes.
So you wanted a conversion of the proceeding from 74 to 73.
My lord.
Which is the larger legal point.
Against me,
Which is the larger legal point to be answered, whether this conversion or switching over is permissible in view of these special facts which has come up. So this is the only point.
75 to its permits, my lord.
So that is what we will hear when we can, or we can hear out the matter without the counter.
In the fact of the case, there is no allegation against me, my lord. Only the allegation is the supplier is.
It cannot be converted to 73.
Are you ready with full argument today?
My lord.
Are you? No. It's a pure question of law. What counter? The available documents are there.
My lord.
So are you ready today?
My lord.
We'll have to answer many queries.
My lord.
Yes?
2 weeks after we take.
Not 2 weeks.
1 week.
Can we come? Can you come on next Monday and argue?
My lord, after 15th, my lord. My lord, there is a marriage in my house, my lord.
Oh. Yes. Congratulatory time is given. Congratulatory time is given. Yes, on the prayer of the petitioner, let this matter be listed on 15th. It is however made clear that the point raised in the instant writ petition is a pure question of law and can be conveniently decided on the basis of the available materials. In such view of the matter, the exchange of pleadings is dispensed with. This is the matter on 15th for final disposal.
Not 15, but 17th, my lord. 15th is beginning, my lord.
Yes.
Item number 6.
Yeah,
But it is 17th, my lord.
Matter relating to land acquisition.
Yes.
Item number 6.
So it's a single judge matter. It is a single judge matter.
Division based matter. Matter relating to land acquisition.
Are you ready?
My lord,
Not know, sir. Honorable Chief Justice is the master of those stories. But no matter is assigned to this way.
Yes, what you say, what is there?
Petitioner challenging the rejection of the division bench 2 with Justice S.K. Sahu and Chitta Devidas.
List matter before regular bench.
Item number 7.
Well, a small indulgence, my lord,
In this case, the petitioner have challenged the order dated 12/10/2023 by Annexure 11. The fact of the case is like this, my lord. The petitioner said the village of Jafarpur of the district.
Madam, there are serious allegations. What to do?
Time may be given to get instructions in the floor.
But you have rejected.
Well,
but they have raised the flag, the very important issues.
Need some time.
This is a MP fund. So there is a prerogative of the MPs.
MP has given 10 lakhs rupees for construction of the
Correct.
wall.
Has he come up with any allegations that my money which I have allocated, because every MP is entitled to invest certain amounts he has been given. Has he come up?
We are the villagers.
Maybe, sir, the money is not yours. He has been allotted money for the purpose of improvement in his constituency.
Minor.
And he has provided the money.
But
If he finds there is difficulty, he will raise an issue.
My humble submission before my lord is that that work has been conducted, but physically no work has been conducted. My lord, kindly have a
But the collector has said that everything has been done.
Yes, my lord, kindly have a glance to running page 12. Under RPA Act, I have asked for the villagers have asked for, and where para 3 of the running page 12, photograph of both the roads at the time of inquiry over the.
No, answer is that these photographs are not available.
Next, 4 is the government letter for modification approved project under empty lot of the basis of the resolution of the Gram Panchayat. Next, in 5, there is no such photos of the project available in the file of which longitude and latitude said project.
Absolutely.
So no work has been.
What are you talking about? The work has not. These documents are not maintained. That does not mean the work has not been done. Let us do. We are appointing any officer of the court. Remember, let him go. If we find, then we will impose a huge cost on you for wasting the court's time and then inviting everything to be done. If you say that it has not been done, you are raising a very serious question when the collects everything has been done.
My lord, but.
So it's if you agree, then we can
Let it come next week. I will take it.
If it is found, no, the unsubstantiated allegation, then
Withdraw and go, sir. Mr. Gadai.
Obliged, my lord. I permitted to withdraw, my lord.
Mr. Gadai, Learning Council for the petitioner seeks permission to withdraw the writ petition. The writ petition is dismissed as withdrawn.
Item number 8.
Well, the picture is the owner of a IMF launcher.
You are running the virus of certain,
Sorry, my
step. You are challenging the virus of certain statutory provisions.
not by the statutory provision actually, my lord. My simple prayer is that we are not allowed to leave the liquor for 60 ml, 90
Come to
ml.
your prayer, sir. You have said that you be accused upon the
Yes, sir.
parties why
Yeah.
this honorable court ought not to strike down the clause 3B of part D of the excise policy. Within excise fees, duty, margin along with the regulatory guidelines for the year.
No, my lord, the only contention of my prayer is the.
But your prayer is this.
My lord, the only contention is that I may cannot permitted to leave the.
If the policy guideline, if it has a statutory flavor, permit or restricts, then without the provision being strike down, how can you?
In these type of some cases where earlier orders have been passed, those cases have been posted to 5th May. And during that period, 180 ml has been allowed to be.
Allowed to mind.
That is
The
the
order is there, my lord, in my favor, but some mistake was there. My writ petition, that's why I have filed an amendment in the writ petition.
Where is that order?
Okay,
Well,
order.
here is it.
Where 5th May.
5th May. My Lord Justice Arindam Sinha sitting with.
On Friday, the batch of cases had come.
Will it be added, will it be tagged with those matters?
Yes, ma'am. Well, my issue, my amendment.
180 ml.
Yes.
Yes, well, 180 will, I am also allowed to leave the 180.
180 ml, we are permitting you.
Yes, yes. Unless my amendment is there. That to
You are passing the same order and tag is not.
Fifth May, 5th May.
My Lord, 5th May.
Item 9.
May be
Mine has been rescued here.
Where is the clause?
If you model contempt, it will go to the assignment.
You'll also select.
We are.
This order was passed by.
My Lord, I agree with my
The
Lord.
writ appeal order was passed.
The writ appeal is filed by the petitioner, my Lord, in WEA number 624 by 2025. That order was, you are to given the interim order.
No, that order.
Yes, my Lord.
Page 12.
Correct. Now,
Page 12.
now it was the acting chief justice with Justice Sahu.
Yes.
Yes, my Lord.
Now Justice Sahu is available.
Yes. The bench comprising my Lord Justice Sahu.
No.
Sinha. My Lord Justice
This, the prisoner has complaints of the willful and deliberate violation was passed by the acting chief justice as his lordship the then was sitting with Justice M.S. Saab, who is available. Let the matter be placed before the chief justice for an appropriate constitute a bench with Justice Saab. Do it there.
My lord, I pray one thing. Along with the WA number 624 by 2025.
Wow.
Credit appeal number.
What is this? Go to the regular case.
Yes, ma'am.
This matter.
Army contempt has nothing to do.
No, my lord.
Contempt has nothing to do so far as the merit of the appeal is concerned.
Yes, my lord.
So let it be listed before the assigned bench. Which is the assigned bench for WA? This.
Yes, my lord.
This that.
This matter is listed on 29th court.
This.
Ma'am.
WA.
Ma'am.
Where? You want to hear out the WA.
That writ appeal has already been directed to be listed on 29th of October.
There is the order.
So list on 29.
On the same day.
On the same day. How do we?
Well,
Available bench.
It will go to him.
For orders item number 16.
public.
Condition of 5 days. There is a, is appearing in 16.
I am done.
Have you served? Have you served the copy of the condemnation application?
Condemnation application and this is first time coming.
Service of the copy of the application.
Yes, it's notice on the question of admission as well as limitation.
Have you given a notice?
Sir, notice is not come.
Yes.
To whom you will serve notice?
My lord,
The opposite parties, no?
opposite.
Respond.
Issue notice to the opposite, to the respondents on the question of admission as well as limitation. Blah, blah. List on 14th May.
70.
Also,
Limitation notice has to hold this case, man.
true, sir.
When there is a limitation was
I'm accustomed to the different kind of a procedure. That's why I'm just trying to figure out.
first of all, notice
There,
has
what
to-
we do is that immediately when an application for condonation is filed along with the appeal,
the copy is
then
not
it is the appellant who is directed to serve the notice directly and file affidavit of service on the returnable date showing that the
But
service
here-
has been effective. So here the notice is to be issued.
Yes.
So you have to file a requisites.
Yes,
So you put in a requisites by day after tomorrow. And we are making it returnable at the
Yes,
shorter
ma'am.
time, sir. It's a question of limitation.
Yes, man. Here our procedure is limitation which we condone it. If your lordship not at the first admission order or you not condone, ask for go to the other side. And that case will only file the
No
requisition.
condonation, he has accrued a right to be heard, to oppose.
My lord, no, this is the procedure of this.
I never,
That's the law.
without hearing the other side, I never.
Condonation application is never decided ex parte. A right has accrued after the limitation has intervened.
Unless notice goes to other side, how will appear and take notice?
And that's why we are.
Right, that's why. There will be case, my lord. There is delay of 217 days.
Anybody is appearing?
Yes, yes, I agree. This is the first case, I think, delays of 586 days taken. And moreover, my lord, what the
In both the cases you are appearing for the.
yeah, all the
respondent.
three cases, common judgment of the Honorable Single Judge.
Three cases.
Three cases, yes. There is a common judgment, the case of my termination of service that was allowed. And my lord, some private parties, they filed a writ appeal. In this honorable, three writ appeals were filed. And the state was also the party in that appeals. And appeal was also disposed of by some modification of that order. Our termination order was set aside by the Honorable Single Judge, and that has been upheld by my lord in a writ appeal. Now, how there?
How much delay is there?
Today, my lord, the first case I have seen 586 days, 1 year, 7 months, and something.
And in the second case, the Yogendra Pradhan's case,
Same, almost more than 500 in all three cases.
92 days.
92. These are the delay and more of how it is.
You want to file an objection?
I have filed an objection.
You have filed?
Yes, I filed an objection with regard to that maintainability also. I have raised that issue. Whether
means
my lord, that once a writ appeal has been dismissed, arising out of the same order by the division bench of this honorable
same
court.
order.
Yes, yes, sir, same order.
Yes.
And it has been modified to the extent whatever the direction is. Came a second writ appeal, and the state was a party in that appeal also. Came a writ appeal at the instance of the state after dismissal of that appeal is maintainable. That I could do. But once order has been passed by the honorable division, this honorable court in a writ appeal of the self-same order.
Where is that order of the division?
Mine.
1270.
One order I am just giving. The last I have given it a bunch from the writ petition. I have given it all the orders.
No, this is not annexed with your counter.
No, Lord, because I got the copies. I have not given it because it's only the delay condonation. It was to be.
No, you are taking up your maintainability that
Yes,
why you will hear out this appeal. And you want to have
Phase 2, last para 3 has mentioned, ma'am.
which order you are referring?
My lord, this three order, that is order dated 29/1/24, passed in
124.
the last order.
Phase 3 of the objection he has said, my lord.
Order to this.
What is the objection? That's not been signed. What is flat C?
Here the appeals were the individual, the candidates.
Yes.
So they came and filed the
Writ appeal.
writ appeal.
And
And in the writ appeal, the court has modified the order so far as they are concerned.
yes,
How does it prevent them from filing the appeal?
my lord, my response submission is they were the parties in the first writ appeal. So they did choose to file an appeal. After the disposal of that order,
Yes.
then coming up with a writ appeal. That is
What-
my response submission at a delay of 1 year, 7 months.
That will be on the question of the intention. But that does it affect the right? The court may refuse to exercise the discretion, but that does not mean it is not maintainable.
No, my response submission is once an order is passed by the division bench of this honorable court, upholding our the order in the single judge. So
Now,
can
please consider when a judgment is passed by the single bench, then it upholds the contention of the writ petitioner, not in its entirety, say for 70% or 80% of the prayer was granted, denying a 30% prayer. He challenges the order before the appellate forum in relation to denial of 30% of the prayer,
Right.
and the court has modified it. Does it mean that it will deprive them from challenging the 70% of the order?
But at the same time, this honorable court has held in the writ appeal that we have to be reinstated in service.
That you are
That
going
is the-
too technical.
No, that's the order, man.
Sir, every employee has an individual right. If a disciplinary proceeding is initiated, then it is in relation to the misconduct of that employee. And you bring a parity.
Here, I want to
Depends
put in.
upon the misconduct
I am
of each
to put
employee.
it otherwise, but I am putting it in my way, subject to my lord's approval. I want to quote it. Once a coordinate bench, I will say, my lord, with respect, because that is a division bench, and division bench deciding the issue involved has directed that we must be reinstated in the writ appeal. That means the order of the honorable single judge was confirmed by the division bench. So can a party who was there before this honorable court take a chance after disposal of the writ appeal and challenge that order? That means now there will be two conflicting orders. Because my lord is sitting in the division bench.
Very
My lord may not like to.
No, I'm giving you a very that interesting because it will really open a floodgate for all an unscrupulous litigant. Can you visualize?
Right.
I'm giving you a hypothetical example. The writ petitioner filed a writ petition decided by the single bench. Writ petitioner knew that the respondent means the authority will go for an appeal. Immediately filed an appeal. And the appellate court says, no, I do not find there is any illegality. Why you have come for an appeal and dismisses the appeal? Does it preclude them from challenging the order?
That is, but this fact is quite distinguishable. Distinguishable from. Yes, my lord have given that example.
Look at it.
This case, it can be distinguishable for the reason, my lord, the appellants have not gone to the court. It is the opposite respondents. They have come before the honorable court. And moreover, an order, the final line
I gave an example.
My lord.
Sir,
Yes,
he approved the court after getting the relief,
my lord.
challenging the order. The appellate court says that how you have challenged the order. I do not find any legality so far as you are concerned. The single-based decision is justified.
My lord.
Does it preclude the authority from challenging the sensitive order?
I respect submission if the authorities are there and for filing an appeal, my lord, there is a statutory limitation. They have to come within that period of limitation. And this.
Then section 5, why it is introduced?
In section 5, we can trace, my lord, 586 days delay. And moreover, the clinching effect in this case is, the case has been decided in presence of the litigant, who is now coming forward with a writ appeal.
Sir, you know
that is the point.
The apex court, the length of delay is immaterial.
Correct.
Sufficiency of the cause is the material.
Correct. There's no dispute about that. But now, my lord, even on that, I said this.
Point, that's why I reacted to it.
Yes, sir.
Nothing.
I have some judgment also to assist my lord. I have the judgments to assist my lord. Here we, because the judgment of the Honorable Supreme Court, as I have understood, the Honorable Supreme Court has said there cannot be two decrees from the order.
What he says is a very basic first principles on the law. It says that there cannot be two inconsistent order or a decree to operate simultaneously in the law. No difficulty. You will find the same notion under Order 9, Rule 13 of the Code of Civil Procedure.
Well,
there are many sets of defendants. If one set of the defendant or one defendant, he has filed an application under Order 9, Rule 13. And if the court set aside the ex parte, it will inure to the benefit of all the defendants, even if they have not filed.
Right.
Because there cannot be two inconsistent decrees to operate simultaneously. That's a very fundamental, basic principles of law. But here is a different situation.
I want to make it
more extensive.
I want to put it the way I have understood. See, my lord, once the party concerned, now is coming before this regulator says the state authorities, they have participated in the proceeding. They didn't disclose for that, yes, we are also preparing ourselves, yes, because government machinery works not in a very prompt way what we act. So they should have said, yes, we are capability to file an appeal. They didn't choose to approach this court.
You have to consider that then it depends upon the nature of the proceedings.
And in the delay petition, delay condemnation petition, they conduct.
The proceeding is initiated against whom? The employee. Each employee is independent,
yes.
His individual right.
Yes.
Each show cause notice is independent, relatable to the misconduct employee.
Yes.
Each proceeding is to be decided independently. If by a common judgment, if one of the matter is decided, does it have any overriding effect on the other, where the facts may be different, where something distinguishing feature may also come out? Is not a common one that one proceeding on a common ground is initiated.
But it is the case when it is only one ground basing on which the appeals were filed. Our case was terminated. No, this case, I will place the fact even if my lord wants to, in the merit of the case, only one ground for our dismissal,
You have to see what are the explanation which is
delay,
offered.
yes, kindly see.
Let us see. We will not dilate into that.
Yes,
academic
that is secondary,
now.
that is secondary. Now, at this stage.
What is
So let
the-
us see what they say.
Hello?
What is your explanation for the delay?
Delay, I have said here, my petition.
What?
Limitation petition, page, my lord, para 3, that the copy of judgment dated 23/8/22, first in WC 3/4/8/22, was received the official CDM and PHO Khordha on 27/9/22. After receiving the same, the official deponent submitted the order dated 23/8/22 along with necessary documents before the Joint Secretary to Government, Health and Family Welfare Department for the course of action. 4. That after perusal of the order passed by the Honorable Single Judge dated 23/8/22, the Government Health and Family Welfare Department decided to challenge the same and communicate deponents.
Sir,
Right.
1 year, there is no explanation. From 23/8/2022 to 16/8/2023, practically 1 year.
Yes, ma'am.
No explanation, what you were doing.
At the
Sitting
level-
right over the matter, that is,
At the
there's no
level of
explanation for
government,
this.
the-
Why the department took 1 year time to challenge it.
That you discussed on 23 August with the Advocate General and filed in 24. I think
Yes,
February.
ma'am.
Oh, there also the delay.
Para 5 that you said it.
May
In
they
the court, the
file.
letter noted
In May.
24/8/23 submitted all legal documents along with the order dated as 23/22 before the Law and Advocate General Odisha for preparation file with the reader.
It was filed on 15 May 24.
Yes.
Sir, can't be done. This is absolutely staggering. Very staggering, very staggering. There is no really a sufficient explanation which has been offered.
At the level of administration, my lord, there is no delay, my lord, that is what.
No, I
Okay.
understand, but there are, now the judgment has come.
Yes, sir.
Yes, ma'am.
Says that you
Large judgment.
have to very decent.
Every day you have to
That's
explain.
replicated it. But you can't take advantage of the procedural lapses or the hazards as a ground for delay. There must be some responsibility based on the officer.
Your lordship, some cost your lordship may allow.
No,
This,
Cost is only when there are certain minor lapses or a delay. Or kind of a lapses, otherwise not. There must be a symmetry.
no, at all not given any reason.
There's nothing which has come out. And when the other writ petition was disposed of,
same day, man.
Same.
Writ petition disposed.
I'm sorry.
Writ appeal. Writ appeal disposed of. Hello, 29/1/24.
These were filed in 2021. These appeals were filed in 2021.
The present writ appeal. No,
Yeah,
other two, 22.
But number is
Yes,
WPC.
that was WA is 1370, 1360, 22. Another was singly it was disputed. In 22, man. All these writ appeals were filed.
You're doing, you knew it in 2022 when the notice was issued. You knew that this matter has come. And it was in your presence. Very difficult. Very difficult to accept this proposition. Have you disclosed in your counter, where is your counter?
Yes, ma'am. I have stated so to the judgment also have delivered. My lord, I have filed an objection.
Preliminary objection.
Yes. And the paragraph 2, next is,
Postmortem general report, you can
As
read
per the-
that judgment, it does not talk about this.
no, no, that they have stated, they've taken a ground that officially delay administrative lapses, therefore I have referred to that judgment. But moreover, my lord, what I have stated, as per the law, page 2 of that petition. Up to that 40. As per the law, every day has to be explained. But here in this case,
There is a judgment subsequent there too.
in the Burelal case also, that has been,
It says that not the everyday is delay, there must be a sequel of events.
yes, my lord.
It does not say a day-to-day
No, but
explanation.
all these two judgments, my lord, knows all these judgments.
The last judgment is of Justice Pankaj Mittal of the Supreme Court, 2025 or 2024.
24, that I have not
The
got it, but then the court
judgments,
says they have to explain, not necessarily. But here in the case, no explanation at all. That I have stated. This first phase, say their two spell, they are referring to no explanation.
The application for confirmation and belief has been taken out by the appellate for confirmation of how many days?
First one, 586 days.
586 days. 601 days. That will be. Thank you.
That is IR number 3346.
3346.
It is a word in the same application that the copy of the impugned judgment dated 23/8/2022 passed in connection with WP within bracket C number 348/23 of 2021 was received by the Office of DA and PHO for the on 27/9/2022. And thereafter, the said file was taken into consideration and placed before the Joint Secretary to the Government of Health and Family Welfare Department for taking a further, for taking a decision on the further course of action. The said authority, after perusal of this said judgment, to challenge the same before the challenge the same by filing an intra-court appeal and communicated the same V-Day letter dated 8/8/2023, which was received by the department on 16/8/2023. It is further pleaded that the CDM and PHO Khurda V-Day letter dated 24/8/2023 submitted all relevant documents along with the impugned order before the learned Advocate General for preparation of the memorandum with an intent to file the instant appeal. Subsequently, the London Advocate General entrusted the instant appeal to the London Additional Government Advocate for preparation of an appeal by drafting the memorandum so that it may be filed within a short time. the pleading for the proceedings that they said government advocate, additional government advocate requested the department, the relevant, the aforementioned department to depute an officer well acquainted with the facts and circumstances, not only for the purpose of filing an appeal, but also drafting the interim applications, including an application for condonation of due. Next one. Such being discerned from the pleading of the appellant for condonation of delay, let us examine whether those can be brought within the ambit of the expression within for sufficient cause. Unquote. Appearing in section 5 of the Limitation. The counsel for the respondent is very much vocal in his submission that not only there is a complete lack of explanation for such inordinate delay, but the instant appeal is not maintainable in view of the disposal of an earlier writ appeal filed by some of the co-delinquent employees who were a party to the common judgment which is impugned in the instant appeal. On the prospectus of the aforesaid facts and the submissions emanating from the record, let us find out whether any grounds have been the grounds are made out for the purpose of condoning such inordinate delay. Next up. There is no quarrel to proposition of law that the court should not be swayed by the length of delay, but must be guided by the merit of the explanation offered in an application for condonation. The length of longer period may be condoned provided the court finds the ground assigned is coming within the purview of the sufficient cause. Semicolon. May reject the application for condonation of delay of shorter periods in the event the explanation is scanty and or not plausible. The next one, the narration of the facts as above does not instill confidence in us has been a sufficient explanation offered therein. The copy of the order was duly communicated to the department way back on 29/7/2022. Yet the pleading is silent for nearly 1 year when the decision is stated to have been for filing an instant appeal. We can well appreciate the steps having taken thereafter, steps having taken after the approach is made to the learned Advocate General of this court, and the time consumed for preparation of the memorandum of appeal, along with the other applications, including the one before us. But we cannot overlook that there is no explanation offered between the period reckoning from the date of the communication of the impugned order and the decision having taken for filing the instant appeal. The state nor its instrumentality can be regarded as a frivolous litigant. The moment the court finds that there has been a lackadaisical, dormant and a lethargic attitude having populated from the conduct of the officials who were supposed to take a prompt decision, and having not taken so, cannot expect the blessings of the court by condoning the deed. The moment the court does not find the explanation to be satisfactory, there is no fetter on the part of the court in condoning such inordinate delay. So, we thus do not find any merit in the application, inviting the interference, inviting the exercise of discretion to condone the delay of 601 days. Accordingly, the application being canned by IA such and such, where it is regarded as a can, so that's why my habit comes. IA such and such is hereby dismissed. As a consequence whereof, the appeal stands dismissed.
All connected matters have been
Same.
All connected.
I do not know, it's the same day, same number.
So second matter, there is a wrong calculation by the appeals.
Yes, sir.
And if we said that it is not, it cannot be 238.
That should be same.
You calculate it.
I have calculated the same 601. Same day of presentation.
So same order passed.
Same.
Item 18, it is related to RSP benefits. State has now given decision to give RSP
It
benefits.
is not related with this.
No.
It's next matter. It's the next matter.
So 18, I may that is related from next week, man.
Who is the other side?
It has not been advocated.
No one has appeared.
It has not been October. Let it come next week, man. Right?
Yes.
Yes, yes.
Can we come after this?
Yes.
18 after
Yes. Item number 19.
There is delay of 39 days. Since my Lord friend has appeared for the respondent, I will serve a copy of on him and let it come next.
Tomorrow? Tomorrow?
Yes, sir.
Yes, sir.
39 days?
Yes, sir.
Yes,
Today we will condone. Do you agree?
It's already window, man.
So,
If you
family
agree-
tension matter.
No, if you agree, we'll.
ଦେଖିନି କଣ ଲେଖିଛନ୍ତି ତା ଦେହରେ ପିଟିସନ ରେ କଣ ମାଗୁଥିଲି କପିଟା କେ ଆଉ ଦାତା पर ପିଟିସନ ୱିଡୋ not
So Coral and
getting
comment is directed to serve a copy of the limitation petition of Mr. Acharya.
no
You have the extra copy.
Extra copy here, not in the file. Copy, sir.
Otherwise, you would have handed over to him just now.
I also called before lunch, please give me a copy.
List on.
ବର୍ତ୍ତମାନ ସରି ଯାଇଥାନ୍ତା ନା ଆପଣ କାଲି କାହିଁ ଆସିବେ
15 minutes was left when my lord.
All right, all right.
So I have to take
List on
my-
9. List on 9.
I can understand Udia.
day after tomorrow मतलब day after tomorrow
That is day after tomorrow.
Again.
9th is day after tomorrow.
again
Item 20.
Apology, my lord, on I have not filed the requisite today. I don't want to not file the requisite matter.
Mr. Misra, when you will file? Tomorrow.
Tomorrow.
Undertakes to file the requisites by tomorrow. Office to proceed. List on June 12th May.
12. Item 21.
Sir.
There is a delay of
Sir.
copy not served. Notice has to.
So put in the requisite for service.
Yes.
But you notice, blah, blah, on the question of limitation and admission, blah, blah.
This matter can be disposed of in terms of the recent amendment.
14th
Their presence.
14th May. 14th May.
Mine. Item 22.
What is this? Unclaimed. Unclaimed or absent? Service?
The return, so must be there in the for visitation right now. When the
Visitation right, otherwise he appears.
Visitation right was already there in the lower court with him.
Their presence.
He is my only son, my lord. Only son, aged 12 years.
We appreciate. You being a mother has a great right of visitation, no doubt about it.
And that was there.
So let them come because the child is in his custody. And you come immediately. You will ensure.
And another there is there in respect of restraint to remarry. The other side may remarry in the meanwhile.
When the decree was passed,
He, appeal is within the period of limitation.
yes. In the IA,
23. This matter will be taken up 2 weeks after, because I have sought for instruction from the collector Younger as well as from the collector Ganjar.
Condonation application is in the.
Condonation, there is only 45 days.
So that is what we can dispose of. The condonation.
May I take the 2 minutes? Because this appeal is probably not maintainable. Appeal is probably not maintainable. May I just?
Why it is not maintainable?
Yes, because there are also, I responded.
This is an execution.
Yes, now execution of a court sale. There was a court sale happening by this Honorable High Court in a com case. I was a bona fide purchaser. I stepped in. I was willing to participate in the auction.
That can we do it at the time of this condonation?
If you also sees the
Only thing is that the condonation has to be decided on the basis of the explanation so offered. If the explanation appears to be plausible. So far as the merit of the case is concerned, you can take a preliminary objection when it comes for review.
you'll also only delay only para 3. Is there?
Are you opposing?
I'm not. I'm opposing.
Say that either come with a clarity. Either you want to oppose, tell us that you want to oppose. If you do not want to oppose, let us decide this section 5 first.
Let me record my consent, but there's a 45 days of delay. Also, I will not stand in the way. In our calculation, is 56. their calculation is 45.
What is our officer has said?
53 days.
53 days, so in between. Neither 56 nor 49, it is 53.
They have more agreement, the appeal shall not stand in the way of objecting that confirmation.
Ye 1 of 2025. It's Das and for the petition and Mr. Binga, land counsel for the respondent. There is next one. There is delay of 53 days in presenting appeal. Stop. Upon hearing both parties and considering the grounds mentioned in the limitation petition, we are inclined to condone the delay. The delay is condoned. I disposed of. The delay in presenting the appeal is condoned. I disposed of. Then in writing the appeal.
Now in the appeal may submit.
Yes.
For admission.
List the appeal.
He did after 2 weeks.
He is seeking a.
1 week after, so that I can get instruction from the collector.
Ganjam probably not a party in this proceeding. So I fail to understand what my learned friend would take instruction from him.
Whether you were a party.
Collector Ganjam was not a party from whom he would.
Oh, I was asking him whether you were a party.
Yes, ma'am. Yes, Collector Ganjam was.
Your Lordship, there were 2 executions. Now they have preferred an appeal from only one execution proceeding, and the other they have complied and did the deed of right.
So in this execution petition, whether they were a party, they were not a party.
They were a party, sir.
So if they were a party, then no need.
Second party was the second party is the
2
collector.
execution case disposed of by way of a common judgment. In one case, the appeal has been heard. The other case, I want to seek instruction. What is the that is the only.
In this case, at least he was a party.
He was not a party.
What are they doing?
You kindly see the first title in this appeal, Collector Mayurbhanj, because with regard to Ganjam, the conveyance has already happened.
No, you come to see in the execution case, annexure 1, execution case number 7.
This is 6. This is an appeal from execution case number 6.
6.
Yes.
Where is 6? So where is 6?
If your Lordship sees in the first title, in the list, it's execution petition number 6 of 2020.
But what is the he has appealed against execution 6.
Yes.
But you filed the petition of execution
Where is
7.
execution 6?
My Lord, may kindly have a glance to page 70. Page 70 of the appeal petition, my.
Yes.
Page 70.
That is the judgment.
That is the judgment. Your Lordship may kindly see at the top. Execution case number 6 and 7.
No, 7
Both.
I find. Page 15.
Maybe, but what are you appealing against?
Page 15 is the cause title of 7, but by virtue of the common judgment, if your Lordship will find that page 70.
Yes, sir, Mr.
Yes.
Das.
Yes.
Because you are appealing against a common judgment, therefore you are questioning both the execution proceedings.
No, 1.
Then you are questioning 1. Huh?
Yes.
What are you? Which was that execution proceeding? 6.
That is 6.
Yes, he is there.
6 where Mayurbhanj is a party.
Mayurbhanj is a
It's a party. So it's a Mayurbhanj.
But Mayurbhanj collector is not the petitioner. Ganjam collector is the appellant.
Mayurbhanj is the petitioner and Ganjam was in 7.
Yeah.
In the appeal,
In the appeal,
Collector-
Mayurbhanj is the party. And 6 Mayurbhanj is the party.
Yes.
So no difficulty. So he's challenging 6, but wrongly annexed the order of 7.
The order was
But it's a common order.
Yes.
common.
So one appeal you have filed, another you are in contemplation.
Yes.
We will consider it. Take a plea at the time of admission.
Yes.
Because it happened.
We are not going to make you give you any advice.
Then your submissions regarding maintainability is not so.
No, maintenance I have. If your lordship is pleased to hear me, then I can open my submission.
All right, appeal.
Maintainability of the execution appeal is to be heard, then first it is to be heard how the execution petition is entertained after 3 years of
The objection, be ready. We are not taking them by.
But if
the
holiday in character, can it be on 21st?
21st. Okay, 21st.
21st, 22nd, whatever.
21st.
For admission item 24.
So Partners have been married and an AG is to number this matter, your lordship. He's from his legs in another court, your lordship. He can post it to next week. The Partners have been married and AG, my colleague, is to approve in this matter. He's on his legs in another court, your lordship.
Then you want to pass over.
Next week, your lordship, there also he's on a criminal appeal.
Who is the other side? Anything, anybody, nobody has been noticed, given a notice.
Delay has gone, also notice has gone, your lordship. Mr. Jafrullah.
I am. There is a delay.
It has been condoned, your lordship.
Want it next week.
Next week.
Listen 29. Listen 29, that's prayed by Ms. Patnaik, Portland and AG. Other side, Mr. Kamila. Yes.
Item
One indulgence, your lordship, what please keep that matter on 22nd.
21st.
But my learned junior will
What is the?
And so for other cases are concerned. First, we put it appeal as other appeal. Case is that, my lord, the petitioners, when the petitioners, they were working in the university, my lord, in different hostels, paid out different hostels. Hostels. They were paid out of the fund collected from the students residing in that hostel.
Warden.
By the warden. By the warden and from out of the fund collected by the students. They were not directly engaged by the university, nor they were paid from the contingency of the university. Or they are regular, the posting was also not against the existing vacancies. My long senior filed the petition and honorable court said that yes, they should be regularized, having a scheme. That is the case matters. There, matters the university has come up in appeal. The scheme matters two. That the scheme required the regularization of 78 employees matters, which has confirmation of the honorable Supreme Court. It was limited to 78 number of employees.
78 numbers
of employees, those who have already got regularized, these are all superannuary. But after this regularization and retirement, the post vanishes. Well, now humble content of the honorable court minors observing this in paragraph para order number 12. Paragraph 12.
For how many periods they had worked for?
So someone so far as the appellant, so the first appeal, according to him, he has worked for 5 years up to 2019.
They are terminated.
After the Uma.
They are still continuing or they are
continuing?
They are continuing. Then you have to consider.
Yes, my lord. They are continuing.
We are continuing.
They are continuing, paid out of the contingencies. No,
they are paid out of the contingent fund.
No, that contingency not from the university.
Okay, that is what I am saying.
Not from the university. So the humility not from the university. The students, those who are residing there, the collections
they are contributing to that.
Yes.
Every student who is availing the facility
Yes,
of a hostel is contributing.
The voters. The voters, man. Those are staying there. Now, question is that they say that we should be regularized. For the purpose of regularization, there is a requirement. My humble contention. contention, my lord, so far this is concerned, my lord, kind of last, my lord's direction, observation and direction, my lord, order dated 13/3/2025. Of, my lord,
By a single page or what?
no, division, my lord, so other topic. Last one, last one.
Mr. Patnaik is appearing for whom?
I'm appearing for the university on the last matter.
On the last matter.
You are
In that,
For the university. The
You are appearing for?
Appellate, no.
since we have a panel of counsels in the university, so, but I will always agree
you are
with
ready, Mr. Mahapan. You are ready.
Well, only thing is I am dead man, but I see the contention matters, I will place it, there is no problem. With reference to the judgment matters, I can place it. The thing is that I am bound to comply the order of my matters. Paragraph 3, matters say, on perusal of paragraph 19, may I read my?
Yes.
On perusal of paragraph 19 of the impugned judgment, we require assistance on demonstration of finding on fact and direction made on the basis thereof. The paragraph contains supposition in contemplating contingencies. Appellate will also submission of respondent number 1 that a scheme confirmed by the Supreme Court exists. That requirement, that information we required, but unfortunately the register got transferred. That is what we create 2 days time, 2-3 days time.
Yes, sir. They wanted to have the, the collation of they wanted to have a collation of a data on the basis of that order. So they are praying for 2 days time.
Yes, madam.
Yes.
2 days.
Yes.
All right.
Yes. Yes.
Mr. Mahapatra.
It may be next
For the
week, madam.
Next week.
Next week.
Mr. Mahapatra and counsel for the appellate. 6 time to get the scheme in terms of their direction dated 13th March 2025. Mr. Patnaik and senior counsel along with Mrs. Patnaik with for the respondents. List on 16 April.
Yes, madam.
my lords for other purposes, your lordship may kindly record my name in the last.
In the last item, record the name of
So
Mr.
for me,
Patnaik.
my lords, along with my friend Mr. Rao.
Obviously for some good purpose.
My lords.
Oh, bless you. Case right. Three Mahapatra and Mr. Rao. Report nine. Report Mahapatra senior counsel and registered.
Item 29.
Is a case of
missing keys of HON'BLE, which is a petition in the nature of public utility. There was a prayer for tabling of the report of the commission according to section 3(4) of the Commission of Inquiry. They filed one affidavit on 10 July 2024, stating that it was decided to place it before the assembly. It's since it's 9 months, nothing has happened.
No, that is not. Let me. This case has a very long story to cut it short. There is a treasury of Lord Sri Jagannath. When the inventory was made, when government took over in 1952 by way of the legislation. In between 52 to 1960, when the rules, Jagannath temple rules came to be formulated by the government. So there was an inventory of the Ratna Bhandar. They call it, that's the Lord's treasury.
That's the treasury, yes.
That's the treasury.
James Treasury.
Right. Not only James, variety.
Ratno, when you use the expression, that's why.
Precious James, everything, diamond, many precious bloodstones which are not yet. In 1978, there was an inventory. After 1960, there was a high power committee headed by the then governor of the state, a 9-member committee. They made an inventory. So thereafter, there was no inventory. But surprisingly, in 2018, there was a direction of this Honorable Court for repairing of the Ratna Bhandar. Because the Archaeological Survey of India, they gave a report before this court in another PIL.
that it requires repairing. So therefore, the temple administration, they were directed. One amicus curiae was also there. But when they went inside the temple, interestingly, the keys were missing. Keys were supposed to be kept in the government treasury with the seal and signature of the collector, district magistrate of the district. Keys were not there, but they went to the temple to open the lock without the keys. So somehow the matter was leaked to the public. So several PILs were filed before this honorable court. One such PIL, my lord, which came to be disposed of by the then Chief Justice, my lord Chief Justice Talpatra, so that judgment by my lord Justice Prab, let your lordship may kindly have a look. So this is the judgment, my lord, wherein
His main prayer has been complied with.
Prayer 1, 2, and 3 has been complied with.
That is the main prayer.
Yes, that is the main prayer. But the number 1, that is not when these keys were missing because of the demand by the public, a commission was set up by the government in 2018 by one of the honorable retired judges of this court, Justice Raghuvar Ras Commission. It submitted a report. So that report was not placed, though it is directory at section 3. But still then, the ATR, if the government proposes to place it before the assembly, it is to be tabled. 6 years passed, nothing was done. In July 24, after the new government was formed, we have filed an affidavit that it was placed before the cabinet. What is to be done? That was the last affidavit available on record. But what I am submitting, your lordship may give me some reasonable time. In the meantime, let me discuss with the government and revert back to the lordship what they are going to do with the report. But in the meantime, that is one aspect. That is with regard to who are the persons responsible for keeping the keys and why was it missing. Those aspects.
You'll have to fix the responsibility because somebody must be.
No, now, my lord, pursuant to your lordship's direction in this judgment, a committee was formed by under the chairmanship of Justice Vishwanath Rai, and the keys were admittedly missing, my lord. So they had to break open the lock, and now the jewelries have been shifted to a temporary place inside the temple.
It has already been broken. It is broken.
We have to, because that was the.
Then the inventory was made.
Inventory is yet to be made. Now the repairing work is going on.
How can you do it, sir?
No, that is under lock and key. It has been shifted by not only one. There is a multi-member committee that was done. This was one of the.
But Mr. Advocate General, the one thing is to be done because there was already an inventory way back in 1970s.
We will compare it now, Miller.
That is what is very much necessary. I was aiming at that.
Correct. It is an issue for us. We are deeply disturbed.
Yes.
So, that was also, I was incidentally the petitioner's counsel. Your lordship may look at this judgment. So, this was argued by me. So, in 2018, we came before this court. That where did the key go? They remained silent.
Before shifting those precious, the gems.
It's a very sensitive.
I think there should be another inventories to be done.
That's correct.
And make a comparison. If there is an addition that's very fair, if there is a shortfall, then
no, there cannot be an addition.
I do not know. That's why I just said if there is an addition, good. No addition, then
Lordship is absolutely right. If there is something is missing, then the responsibility is missing. Your lordship is absolutely right. Bow down. We are on that. We are working on that. What happened? There are 3 compartments. Your lordship may kindly. That is also dealt with in Rule 5 and 6 of the 19. Your lordship have a look at the temple rules.
No, there are 3 compartments.
There are 3 compartments.
Yes.
One is we are concerned with the inner Ratna Bhandar.
Correct.
There is in the inner Ratna Bhandar, whatever ornaments have been kept, that is never used.
Okay.
But the outer Ratna Bhandar, there are 2 compartments again in the outer Ratna Bhandar. One is the daily use.
Okay.
The ornaments to be used during the festivals, because Lord Jagannath, there are 12 Sunavesas. This Sunaves, they call it.
in a year, apart from Rath Yatra, every month also there is a tsunamis. So those ornaments are taken out from the outer Ratnamanda. Here the keys are with regard to the inner.
I understand.
The ornaments which are never used,
Never
they are
used.
kept. But that this periodical inventory was done in 1978. That was the last. For long, 4 decades, there was no inventory. So this issue arose, Miller, when in the pretext of repairing of the Ratnamanda, pursuant to the direction of your lordship, when they went inside, admittedly the keys were not there with the
No, that I understood. So
yes.
So it has now been the lock has been broken.
Lock has been broken.
Broken.
Because keys were missing.
The precious stones or gems have been shifted.
Shifted inside the temple, not outside. It was with
That
police.
is what is shifted to a more secured place.
Right.
And now you are contemplating to have the entire renovation of that inner Ratnabanda.
Absolutely correct.
Now, what is the situation? Has it been completed
No,
by
it
an
may
archaeological survey of India, or it has?
It's been done by ASI because ASI has the nobody.
No,
can
that's why I say archaeological survey of India. Has he undertaken everything and completed it?
Yes. No, it has not been completed. So it will one. You are for ASI. Yes. So ASI has asked for some a few days because your lordship knows this repairing work cannot be done on a
Required to complete it.
Now it's
Because you should ensure that the originality is not lost.
Right.
So this is what your primary object should be. So how much time do you require to complete it?
before Snana Purnima, it will be completed.
When it is?
June. Because the delay is due to because lack of time that is required.
But actually, this process, all this, this inventory, this opening is started after the new government was formed. It was not being opened until. So therefore, the affidavit which was filed in the last April, they were registered. Government was, but in the change scenario, we wanted to go for this inventory. It was opened because a committee. Yes.
Sir, because there is no better, there is no restraining order.
Right.
They cannot go.
Right.
They cannot do
So that's no. Rather, this court appointed a committee, directed the government.
The restoration or preservation
That's
of a particular portion of a temple.
Right.
Because the inner Ratna Bhandar is the part, integral part of the monument.
Your Lordship is absolutely
is a temple.
Right.
So it is their primary duty to preserve it as it is, because it has a lot of religious and sentimental values.
Right.
So that has to, that cannot be covered, that cannot be undermined in any sense.
Right.
So we wanted that everything to be done and to be placed in an original position.
Right.
As it was. So they wanted a 2 weeks time.
2 weeks they cannot do it. Not they can do it in 2 weeks. I have discussed with the SI people also. I have discussed with the DGSI. You can complete. They can come because it is done only 1 hour, 2 hour every day.
To be completed within June.
So let them be given a tentative. Your Lordship says, but I don't think because
Subject to available.
because every day they are working 1 hour, 2 hour like this. That is during when it should not cause any dislocation to the devotees. It is inside the Jagmohan and Nathmanda. Your Lordship must have Justice ROUTRAY was also the law secretary. So it is situated in such a place. If they work 24 hours or 10 hours in a day also, that would be inconvenient to the devotees. So they are doing it, Milord, in a way so that it would not cause any dislocation to the devotees, darshan, everything. So I think they are doing it for 2 hours, 3 hours like this. And your Lordship is right that the originality of the temple is also to be preserved. So they can't do it in a hurry or in a. So now that the jewelries have been kept, in the presence of Gajpati Maharaja's nominee, a high power committee will not be constituted that is there on record, and that is being headed by a retired High Court judge, Justice B.N. Vishwanath Rao. Several chartered accountant persons of repute, they are there. So this committee is not directly monitoring. So this repairing part of Ratna Bhandar is the job of the ASI. So ASI Millard has been working on it. And they may take some time. I do not know what would be the time period. In the temple precinct itself, it is pillared under the lock and key. The director, this committee, everything pillared. So it has been locked in the presence of the district magistrate. In the temple precinct itself, Pillar, it is under the double lock. Whatever procedure is contemplated under Rule 6. Custody of the temple administration, Pillar? Yes. There is a chief administrator. Yes.
Now this repetition has already been disposed of with this direction that they would make a collaborative efforts not only on conservation of
that is only relating to prayer number 2 and 3. Prayer 1 is still pending.
Prayer 1 is what?
The tabling of the commission's report with regard to the missing. Let me explain.
Then controversy is the missing case.
So far the inventorization part is concerned. You have to miss that.
The prayer.
He is breaking.
PI.
Yes.
You can stress the prayer.
That's correct. That is of the new lordship. So we have two aspects. One is with regard to.
I understand. Now, how much time will you take to place it in the floor of the house?
6 years squares were taken by. So we are.
Now, how much time will you take to place it on the floor of a house?
No, floor of the house, so it is debatable again because the
government to send it to a cabinet.
It is to be placed before the cabinet first.
So has it constituted a cabinet?
No, cabinet is already there, Mila. A cabinet is already.
Committee.
No. A cabinet is cabinet. So therefore, we will do that. We'll place it. We'll have 2 months. In the meantime, let us work out. They distinctly claim that it is it is not mandatory to be tabled. But we may take a revised stand. Sure.
Anup Kumar Madhav.
Yes, sir.
Jagdish Kumar.
Council for six, some meets, that some time is, some more time is required to undertake the renovation work. Or
Repairing.
Repairing. It's all. From 15th May.
Keep it out May
15, let us see the progress.
Your Lordship, please.
All functions are ensure they are part of the regarding repairing and other works.
Of the inner
To repairing part of the inner of
But I filed an interim application. Calling for a status report of the inventorization of those precious jewelry. Yes, ma'am. Yes, ma'am.
No, copy we have found. But inventory has not yet begun. How can there is a committee already may not pursuant to the direction of this copy?
Serve another.
Sorry. Give a copy.
One more.
There is yes already a committee pursuant to your Lordship direction in submit party case.
What you say, whatever he has prayed for,
Right.
put it so that he will be able to go.
The idea. Idea number what is
488.
488 by 25. Maybe solve.
Item 30.
15th of May.
The Robinson application flag B. That is I number 12572 of 2015. Flag B now. B. I was party to the before the land. Original code.
You were a party.
Yes, I was party before the land.
Then why
He has omitted
party in this?
He has omitted me, made a party here before the application. That's why I filed an application for insurance.
What was the application in the trial court?
In trial court, may not 6 some 19 has been allowed. 19 of the Ocheri Act.
19.
It's been allowed and subsequently was appeal also.
Pending or upon the order of the.
Yes, no. Yes, no.
It was but the later on, the government again they filed another petition before the
Who?
This
intervener?
No, not intervener.
DT has filed.
DT has filed.
DT has filed application extension of time to implement the order.
But there was
And in
a
original
modification. There was a departure from the order of the first order of the commission. Then that modification we have challenged.
So if they are the originally they are the party, they have to be made a party. They were a party in the original one.
They are one of the beneficiaries because I am aggrieved and I have paid. I am a private party.
But will you not include that because the DT approves for further direction or for implementation, what? Of the earlier order?
Earlier order.
Correct. So really, in effect, something is that they are required to be heard. So they are a necessary and proper party in the perspective of. So let them be added as a respondent here.
Yes. Mr. Write in IA number 9 double. I write in 1 2 IA number 12572. Mr. S. Monty for the writ petitioner and Mr. T.K. Misra for the intervener. Considering the fact that the interveners, na? Considering the fact that the intervener was a party in the original application, we consider him to be arrayed as one of the opposite parties. Accordingly, the prayer for intervention is allowed. And the intervener is added as OP number? OP number 5. As OP number 5. OP number 6, na? 6.
Number 5.
5 is the Commissioner of Endowments.
4 is the
Added as OP number 6. The petitioner is directed to file a consolidated writ petition, a consolidated cost item within 3 days. Ms. Naidu for the endowment. Based on 6th May.
Item number 32.
No, they have not filed. Yes. I have.
No. Mine. Yeah, I'm appearing for the endowment department, my lord. Your lordship, here, the order under section 41 is under challenge. It is appealed.
Madam, why you do not file a Waklatama? Your right to be heard. After you file a Waklatama, a proper application. So the department has said that you have not filed Waklatama. Why?
Generally, your lordship, either because we are referring to the appearing on behalf of the judicial officers. So that is the reason sometimes it is given a go.
No, you.
I'll file, my lord. I'll file. I'll appear. I'll file. Because the commissioner has changed, a fresh file.
Ms. Naidu undertakes to file the Dinava within 2 weeks.
Tomorrow, that's I'll file it tomorrow.
Within 2 weeks, based on 7th May.
Lordships.
Item number 33.
The petitioner because of almost single judgments. The writ application was dismissed against the committee. Back to the case now.
Order of dismissal, and it should see.
Yes, order of dismissal
is dated 8th of February 2024.
My lord. Yes, yes, ma'am. That is, you can kindly see
that is at the order under challenge.
Yes, ma'am. That is at page number 63. Starts from page number 63.
What
operating portion is 69.
What the court had held?
Yes, here what has happened, the present petitioner was working as a pharmacist, district hospital Raigada. While discharging his duty as a pharmacist in the active line of duty in the COVID period, he died due to COVID infection. Yes, government issued a guideline for grant of financial assistance to the persons who are in active line of duty discharging in hospitals. If that was issued, people also kindly see that is at page number 56. There, government has directed that 50 lakhs compensation is to be provided to the healthcare providers if he has died during COVID period while discharging. Yes, after death of the pharmacist, his wife.
He died of COVID-19 or what?
Yes. COVID-19.
COVID-19 he died.
Yes. He died.
There may be a normal death.
No, there is a death audit.
But our stand. That is what.
Yes, that is a death audit. And it was found.
Page now 26. You'll also kindly see page 26.
What for?
That is the CDMO's letter to the collector. Also kindly I will be permitted to place. With reference to the subject cited above, I am to intimate that late Ashok Kumar Patra, pharmacist, District Headquarters Hospital, Raigada, was drafted for COVID-19 related work in ward and flu clinic of the District Headquarters Hospital, Raigada. While on duty, he was tested COVID positive on 1/9/2020. He got himself admitted at some hospital, Bhubaneswar, on 3/9/2020. He was undergoing treatment and was declared dead on 11/9/2020 at 6:40 p.m. The cause of death is COVID-19.
So it's there.
Yes.
So he died of a COVID.
COVID-19 while discharging his duty.
Sorry.
Yes, that is why yes, I was entitled to compensation in view of.
Where is that?
Yes, that is you're also kind of going to page now 56. 56. Mike. Guidelines for providing financial assistance to spouse, next of kin of persons who succumb to COVID-19 while in active line of duty and are not eligible for insurance coverage under the Government of India. The coronavirus disease, which is caused by a new virus, is playing havoc in the entire world. WHO has declared COVID-19 a pandemic and state of India, Government of India has declared COVID-19 as notified national disaster to give further momentum to India's effort to fight COVID-19 and to assure our doctors and healthcare workers that their well-being is foremost for the government of India by their due letter number so and so announced the Pradhan Mantri Garib Kalyan package insurance scheme for health fighting COVID-19 to provide an insurance cover of 50 lakhs to public health care providers, including community health workers who may have to be in direct contact in care of COVID-19 patients and who may be at risk of being impacted by this. Also, on account of unprecedented situation, private hospital, staff, retired volunteers, local urban bodies, contract, daily wage, ad hoc, outsourced staff recruited by the state, central hospitals, autonomous hospitals, central on state undertakings, AIMS and INS hospitals of the central ministries can adapted for COVID-19 related responsibilities. These cases are also covered under the said insurance scheme. The scheme has come into effect from March 30, 2020 for 90 days. The Government of India, by due letter number so and so, have enclosed the claim form for loss of life due to COVID-19 and form 2 personal accident insurance claim for accidental loss of life on account of COVID-19 related duty, detailing the procedure, the claim certifying authority and the documents to be submitted along with the claim form. For the Government of India, by date number so and so, extended the insurance package for a further period of 90 days beyond the original period existing of the terms and conditions. In addition to the above, to instill a sense of security among all our healthcare providers, others who are engaged in top battle against COVID-19, Government of India has decided to pay a sum of 50 lakhs to the spouse, next of kin of any person drafted by government or its agency to perform COVID-19 related duties, and in such persons succumb to the disease after contacting coronavirus in his or her active line of duty and meets accidents, loss of life on account of COVID-19 related duty and not found eligible for insurance coverage under the guidelines of the Government of India. Now, there are mandatory conditions for eligibility. To see, the above category persons will be eligible for financial assistance under these guidelines provided they fulfill the following mandatory conditions. 1. They are drafted by the government or by its authorized agency to perform COVID-19 related duties responsibility directly. I am covering because I am DHH pharmacist. The contact of COVID-19 infection must be while in active line of duty and the worker employee must not be on any kind from the duty. Provided that he is detected COVID-19 positive within 14 days from his last day of active COVID-19 related duty and subsequent.
I got it. Then what?
Thereafter, what has happened? Government collector has written to the page number 31, 32 mechanism. Page number 31.
What it says?
That I am treated as a COVID warrior is in.
So that is you have already
qualified.
Placed.
My lord.
So far
after qualification, so I submitted my application for grant of compensation, and that is at annexure.
You, the wife of the children of what?
Ashok Kumar Patra, the person who died. I am the wife. My annexure 5 is the form, and
what is their answers?
My
what is their answer?
They said that I am not in active line of duty. I was wrong.
You are not.
Your Lordship may kindly come to page 42 of the writ appeal, filed by one and that document is been uploaded, wherein the collector sought a advice from the Additional Secretary from Government of Odisha because he was directly not involved in COVID-19 duties. Relevant person is also will find at page 43. Next page, relevant person. Next page, 43 page. In the instant case, late Patro was drafted for routine duty at the drug distribution center for the period from 1/8/2020 to 1/9/2020 and not for COVID management duty involving direct contact with COVID-19 patient. But the CDM and PHO issue certificate regarding his involvement in COVID-19 management. Last paragraph, in view of the circumstances, it may please be clarified. Now the clarification has come, which is available at page 49. That in case will be covered under the program of the very package or not difficult.
You see, now the CMO is the appropriate authority under whose control the deceased was working.
Who was working?
Deceased was working.
Yes.
So the duty assigned by the CDMO has to be performed by the.
During COVID period, CDMO was not assigning the duty. It is the government who was drafting. That was drafting. 49 says.
See,
But
what was the duty according to the government?
Just distributing the medicine. He is a pharmacist.
Distributing the drugs to.
Not at the hospital.
How?
During places. Your Lordship may kindly, for a moment, your Lordship may kindly see that reply given by the secretary, which is available at page 49.
But what is your answer to this certificate of the CDMO?
That possibly I couldn't express myself properly. Page 42, that is why that clarification was sought for, because of the CDMO's certificate.
Now, what the CDMO gave a reply, let us watch.
See, it was clarification was from the government, from the secretary of the department.
Yes.
That answer is there in 49, page 49.
So, what is the stand of the government?
Yes, that's what I'm saying. But you also will find it at page 49. The special secretary to government writes to the collector and DM Dagada at page 49.
No, we got your point. Probably you have not understood us. We got your point. Your point is that whatever duty assigned without drafting the deceased as a COVID warrior, without drafting any duty by the government, all those duties what he is doing will not be taken into consideration. But the CDMO in his letter has clearly stated, you see, come to that page. What is the page that Mr. Patnaik? Yes, come to page number 26.
26. Yes, sir.
It is the clear-cut report of the CDMO.
Again.
Then in view of that discrepancy in the report of the CDMO and the report of the collector, then you sought for a clarification.
Yes.
Government clarified that unless he is drafted with COVID duties, he cannot be declared as COVID warrior.
It has been stated in the counter also at the time of filing a reply.
In spite of that, what is said by the CDMO has not been denied. But our point is that since the fact what is stated by the CDMO regarding assignment of his duties has not been denied to you by you, therefore he should be declared as COVID warrior irrespective of the duties not assigned by the government.
That is your Lordship's discretion to take a decision. But
that is our view that we are expressing. What is your answer? You must know he was not discharging the duties.
Yes.
As mentioned by the CDMO. He was not directly involved. Because you said, but your case is that you are saying that since he was not drafted as a direct duties, therefore he cannot be.
Not only that, in the counter filed before the Honorable Single Judge, there we have categorically stated that he was not performing the duties of a COVID-19 warrior. He was never. I'll place that. It is available at page 51.
Have you counted this letter of the CDMO?
Yes, it has been stated.
What do you say?
The GST then.
At page 52, my lord, certification is based on the approaches required to calculate for the benefits given as not declared here on the ground that you have started for routine duty at the drug distribution center and not drafted for COVID.
That is what you were contesting. He was not drafted for COVID duties. He cannot be declared as COVID warrior.
Who is not
Despite he had worked directly.
He cannot render the duty. One who is not drafted.
He cannot do that duty, irrespective of the decision, irrespective of the direction of the CDMO.
Provided he must render the duty.
Who will certify that he has rendered the duty or not? Who is competent to certify that?
CDMO. I
Then
will be sure.
CDMO has said,
Since there was a discrepancy, that is why the clarification was sought. Without there being any discrepancy, what is the need of asking for a clarification? That is my understanding. At all,
what?
No discrepancy is there.
Essentially, what does your clarification say?
Clarification
says that since he was not drafted for COVID duties, he is not a COVID warrior.
Not only that, my lord.
And the reasons of the learning single judge has also goes on the same line.
Yes.
Since he has not been drafted for the COVID duties, therefore he is not treated as a COVID warrior. But on the face of the same, the letter of the CDMO is very clear. So what is your answer to the letter of the CDMO?
I wanted to place from page 43. That's what I wanted to place.
What is your answer to the said letter of the CDMO?
Yes, it is there. Page 43, for a moment, your worship. Page 43, part of an SR.
You see, that is the policy, that is not factual answer. The actual answer must be in the counter, not in the policy.
Policy.
What the CDMO has said, he has discharged the duty of the search. Where have you answered in your counter?
43 is contrary to 42. 42 there we mentioned late Patro was assigned with duty at drug distribution secretary district headquarters hospital Gayagada from 1/8/2020 to 1/9/2023, which is a COVID-19 management related duty. Page number 42. Same letter.
That is why yes, clarification was sought for.
That's what I
Constable was awarded 50 lakhs rupees.
Government denied.
Constable was awarded with the 50 lakhs rupees by single judge of this honorable court. This is the order on the last page and I have given.
Can a hospital combat that menace of the COVID-19 without a timely distribution of drugs or the medicines?
I understood, madam. What your lordship wants me to answer, I understood.
Provided that drugs are what to do, because they are also interacting, because the people are coming and asking for those medicines from him. He is also in direct contact with those persons who may be infected.
Maybe infected, but they were not coming in direct contact.
If he's dealing with the public in distribution, then he's discharging those duties.
Our stand all along was, my lord, the drugs were not given in the hospital inside that COVID-19 hospital.
No, that is what is the CDMO. I think
CDMO has written.
Says that it was within the
CDMO has written that.
center, within the hospital, and
Yes,
the hospital was totally infected.
Your lordship is correct. CDMO has given that.
So
because of
be
that.
compassionate.
Yes,
Compassionate. Why there should be so much of?
Then over there, your lordship is 100% correct. I cannot dispute that. The compassion should be there.
Why the single bench?
Single bench judge observed that only.
Single judge has not assigned any reason. Page number 49 also mechanically see. No region has been assigned.
Page 65.
Page 49 also mechanically see. That is I know. 69. I am sorry. 69. 69 you also mechanically see. 16 and 7 also mechanically see. 17, 18.
Oh, yes.
Page no 69.
Page 69 it is there.
that needs to be interpreted in a more pragmatic, because it is a welfare piece of the scheme. And therefore, the scheme has to be liberally construed, not to be so strictly construed. So I believe, because once I think the doctor, he is a doctor, CM.
No, he is a pharmacist.
Chief District Medical
Officer.
CDM.
Chief District Medical Officer.
So he's a doctor by profession.
Senior doctor.
So if he has said that he has waived, and you do not know what duty he was discharging, must be discharging duty in the very core area of the COVID in the hospital.
Supplying these drugs.
Absolutely, they are interacting with the people. And the single bench has said that no, there is no, the interaction with the people. I think it was. That's true.
We allow the appeal. Allow the appeal. We will pass it.
Item 34.
What about the other respondents?
The respondents of the state.
So,
Yes, other response.
Yes.
Please.
Oh, yes, the TANDON.
Yes, 6-7 days time for. Because I was in difficulty.
You were in?
You not seeing the alternate to 7 days. I seek accommodation for 7 days.
No. I cannot oppose to that. Okay. Not at all.
Yes.
Whatever time you want.
List on 22nd April, match prayed by Mr. Mahapatra for OP number
7.
respondent number 7.
Item note 35.
For the IPR, I have challenged the restitution of conjugal rights filed by the husband. It was allowed by the.
It's allowed.
Yes.
I'm not sure.
And in this case, notice has not been sufficiently responded number 5.
No, I'm appearing for the part of 5. With leave of your lordship.
Do it, sir. So you waive the notice.
Well, I have got my notice back and I am before your lordship. My. Mother.
Submit that he has instructions to.
We have appeared. Today. Opposite party number 5.
Yes. Appeared for OP number 5 that filing in amount.
Today, my lord, it has been recorded by your lordship's registry.
Item 38.
The Lordship may kindly permit me to withdraw the present application.
Since your lordship had fixed it to 6th May, I need not destroy your lordship, but my termination has been set aside by your lordship. Somebody else has joined in.
Yes, left. Outside has left, he did not object. Yes, already left.
I cannot. Your lordship prefers
Any date shorter than your worship, I mean, these could fix, I will be. 23rd of April.
3rd May.
April. Grateful.
What is that? It's a long time, first week of May.
His termination, his service has been terminated.
Well, that vacancy I appointed.
What's the reality hearing? What is your problem?
She is not married with party, my
No,
lord.
no.
Not necessary.
My lord.
Item 39.
Leave to appeal has to be allowed first. In that case, leave to appeal has to be allowed first because she was not.
39.
38, that 37.
Withdrawn, na?
32.
Permitted to withdraw.
37.
Here withdraw. It's no difficulty. Just give your memo.
No, I am talking of 37, man.
Okay.
Leave is to be allowed first there.
Yes, leave to appeal has to be allowed. Yes.
The lawsuit ended 39.
39.
2 weeks time. 2 weeks. 2 weeks time to file the counter. 13.
Interim order to be continued, madam.
Is there an interim order?
Madam. No course of action, interim order. Interim order is no course of action, madam. It is dispute regarding jurisdictional issue. Next same.
44 is the same.
Item 40. Sorry.
Was there any both items? 44 is 39 both items. I am 44 and 39 these items.
Item 40.
Today, I entered appeal on behalf of the applicant to both. Oh, that is kindly, there was someone who said that I can have a short. No, counter.
In item 40, I have applied for part number 1. It needs 2 weeks to file.
And your part of the pleading is over?
No. I have not filed. I have not filed counter. I played 2 weeks time to file.
No, by submission is there, I am the petitioner. I have challenged the order of the Ombudsman, the refusing to enhance the upgrade the from 6 line. 2 weeks time may be granted so that.
Yes, 2 weeks.
2 weeks time.
Item 41.
41, I payment of 41.
My lord,
Item 41, I received the counter of department number 2 today in court.
In the court.
Yes, no.
I have filed.
I need
Counter on field.
You have served the copy today in the court.
Yes, ma'am. It is for National Medical Commission.
Your lordship will call it 8 weeks after. Lord.
8 weeks.
Yes, Lord, because the petitioner.
It's for rejoinder.
No, I'm not. I'm just submitting, my lord. Why? The petitioner is in Germany, my lord. Yes, yeah, I'm explaining, Lord. The petitioner here is a doctor, registered here, but he did his post-graduation in Germany, my lord. He is now in Germany and he wanted to register. He did the post-graduation there. He wanted to register here as the MBBS plus the post-graduation degree. For that reason, this writ application has been filed. And because the instruction I have to obtain the instruction and
have the regional, and this is the counter of opposite partner number 2 only. Opposite partner number 4 has also not filed counter yet.
Sir, so you have already taken all the instructions in this regard, sir. The issue is very simple.
Yes.
The issue is that somebody who have pursued the technical courses outside the country.
Yes.
Particularly the medical.
Yes.
The MBBS or the medical.
Post-graduation, yes.
Post-graduation or undergraduation?
Yes, whatever.
Both MBBS or MS or MD, whatever.
Yes, madam.
Whether those can be recognized by the Medical Council of India.
That has been rejected. Annex 1 is.
So, there are certain decisions which have already been taken by the MCI in his guidelines, in his regulations. That anybody wants to pursue it or to get himself enrolled under the MCI, they have to pass through this.
Certain process.
So why you want a 8 weeks time for that?
Because here, my lord, the recommendation the OCMR has recommended.
Sir, that has been rejected.
Yes, that has been rejected.
I have seen that page 10 is before
10,
me.
yes.
Page 10 is before me.
On the basis of the 1956 regulation.
So why 8 weeks time for rejoinder? The only issue is take 2 weeks. That normally, my personal speaking, 1 week time I grant for rejoinder.
Fortunate, Mr. Mongal, you are fortunate.
Yes, I understand. Your lordship, my lords have gone through the the rejection order that is. In the court today.
Mr. Mongal, it's time.
First week of May, your lordship.
I'll also file counter for visa restriction.
OCMR has also not filed the counter.
I will file it within 2 3.
I am appearing for UP 1, but
Item 42.
Once counter also will be necessary because Union of India also is a necessary party.
They chose not to, then
Yes. When they choose not to, then nothing can be done. Yeah, lordship, in the first week of May. Yes.
Second May.
Progress.
Item 42.
Yes, I could not make a head and tail from the petition. What you wanted in this petition?
Well, what has happened? I was declared as on top. That is the stay in respect of that application of the internet exposure and public have filed applications under Order 913 saying that this order should be recalled because they could not participate.
It was an ex parte order?
Not an ex parte, it was by contest, but some of the opposed parties could not participate.
The person who did not appear and participate will file an application under Order 913.
To set aside that.
So that has been allowed or rejected?
That has been allowed.
That has been
Allowed.
allowed.
In between, some fact is necessary that after that application under Order 913 was filed on the ground that the concerned person ill therefore could not appear. That was the ground. He filed an memo to withdraw the application filed by him. Order 913 petition which he has filed, he has also filed a memo to withdraw that application. At that stage, some others have come and claimed that they should be also included as parties. They are also Hindu public, they claim, and they should be transposed as petitioners to pursue the application under Order 913. Added some more ground.
Is it not a class action? I mean, the representative suits like Order 1 Room 8 of the court.
No, under the Hindu Religious Endowments Act,
Correct.
public are entitled to participate.
Absolutely. So this is really a class action. If it is a class action, then the public is the very important.
Right.
And under order one rule 8 also, if the petitioner want to reside and does not want to continue, then it is a duty of the court to invite somebody else to pursue the remedy, because
Sure,
the
absolutely.
remedy is the public in nature.
Absolutely no issue there. But the question is, when the petition has been filed on the ground that he was ill, personally ill, therefore could
So
not
then
appear,
how
can the other
party
grounds be
can
taken?
take advantage of
Right.
it?
That is what the question.
That is what is the important thing. How can
And
you
he,
can maintain it, no problem, but
my friend has
the
filed a
setting
counter.
aside of the, who is the petitioner there? Order 9 Rule 13 applicant.
Order 9 Rule 13 petitioner died and my friend is appearing now.
Who pursued, sorry, I understand.
I understand.
Who pursued Order 9
Opposite
Rule
party is
13?
224.
Yes, what has happened, my lords?
One more, just 1 second, sorry. Out 2 to 4 have filed that petition and 3 has died in the meantime. That is what the noting is. Since they are representing the public, Hindu public, substitution is not necessary. But then they have filed a counter, therefore in the first hour I have made a submission that I may be given some time to file a rejoinder, because I have received it a couple of days back.
There, how many petitioners were there in Order 9 Rule 13?
Actually, there were one
It's a single.
single.
So maybe, but the ex parte decree,
Yes.
she wanted to withdraw.
Yes.
Under Order 9 Rule 13,
Deeply.
there are two, it has a two compartment.
Two compartments. Yes.
One compartment relates to non-service of servant,
Yes.
and the other compartment relates to prevention by a sufficient reasons on a day
Yes.
when the suit was decreed ex parte.
Miles.
So this application is on the second compartment, not on the first compartment of the service of servant, non-service of servant.
Yes.
Then in that event, it is relatable person to person
Yes.
who could not appear.
Yes, I'm just explaining in 2 lines what has happened. During the pendency of that particular 30 proceeding, my lords, a petition was filed by that Nityananda Muni, who was a party there. And the Honorable Commissioner, after hearing all the parties, had stayed that order up to 2 years. The order has been stayed and continued. Nityananda Muni is the one of the who has withdrawn the petition. Who
was the earlier
930?
930.
Yes. Then, my lord, in the year 2013, in that particular 30 proceeding, he has gained over everyone's party order was passed. All have filed an objection. That is the will is forced. He has gained over. Then, my lords, these 2 persons have filed a petition in that 30 proceeding to be imputed as a party, because that means 3, one of them died. 2 filed a petition in that Order 9 Rule 13 petition, which was allowed by the Learned Commission.
Probably the query which I raised.
Yes.
You are unable to answer that. We wanted an answer from you.
Yes.
Sir, if you look at Order 9 Rule 13,
yes,
you have said yes.
Yes.
There are 2 things which can be gone into under Order 9 Rule 13.
Yes.
First thing is, if you say there was no service of servant, despite you being made a party.
Yes.
I can understand.
Yes.
You can come and challenge it.
Yes.
Second is that you being a party.
Yes.
Was prevented by the sufficient reasons in not attending the court or participating in the proceeding on the date of the decree when
yes, but
it was passed. Now, you sought for your addition.
Yes.
In Order 213 proceeding.
Yes.
Saying that you are an aggrieved person.
That has been allowed.
Interestingly, I do not know how it was allowed.
Yes.
And interestingly, I do not know how you were permitted to continue with Order 9.
I'm just submitting that one. That has already been over by this Honorable Court and Apex Court. What has happened, my lord? When he filed a petition for withdrawal, he has stated, I am filing this petition on behalf of the villagers. There, my lord, in objection filed by me.
That means it becomes again, that's why I asked the class action or
repetitive action. Thereafter, with the objection of that memo, I have also filed a petition for transposition to pursue the case. His memo was allowed, my transposition was allowed.
Not amend your Order 9 rule.
I have amended.
After addition, did
yes.
You amend your?
Yes, I have amended. Yes.
That is what I wanted.
I amended it. And amendment has been allowed.
And my lord, the whole thing, if your lordship will kindly see, the whole thing, my lord, is perpetuated by fraud by the report of the Additional Assistant Commissioner. Perpetuated by fraud, giving those decisions also. Now, only the 30% is to be tried on merit. That is the only thing.
I think it's a pure question of law that can be decided on.
No, he is now raising the question regarding the validity of the Vilnam and all those.
No, we are not concerned with the validity. We are concerned with the order under Order 9/30, which is the subject matter of challenge here.
Yes. Then you are asking to fix it.
The fact which he said was this.
Yes.
If that being the fact, then what is the ground?
The question is.
We are not entering, we cannot also enter into 32
Yes.
jurisdiction.
Yes.
The point.
30 jurisdiction, we now cannot enter. So we are only, we are only on the question of 930.
Yes.
So if he has amended his prayer, the petition, to represent him as the Hindu public, then he has a cover of action.
That's
So,
right.
yeah.
But what has happened is, after his transposition was allowed, the matter came up to this honorable court. I challenged the locus standi. And here the direction was given that I should agitate these points before the commissioner. Then I went to apex court. Honorable apex court has said that all the points, including the question of locus standi, can be raised before the learned commissioner. Therefore, the first and foremost point that has to be decided by the learned commissioner is whether these petitioners have got any locus standi at all.
Hindu public.
As Hindu public.
See, the relevant party is Hindu public. To be represented by
Somebody, X, Y.
someone who has the cause or the representative capacity, as my lord has said.
Yes.
So whether that point has been dealt with by the
Yes, yes. Point number 1. At page 89, your lordship will see, and from page 90 to 95, he has clearly dealt and filed that he has documented. Is that the finding?
Of a representative character, then whatever addition is permissible, automatic, anybody who comes wanted to be added, has to be added.
But the question is, some more facts, the question is, when they filed a petition to get impleaded, they were allowed to be impleaded and contest from the stage they were impleaded. Those are the.
The stage is Order 9/30.
Yes.
The stage is Order 9/30.
Yes.
Order 9/30 talks about the setting aside of the ex parte.
Quite correct.
So that stage, if the main relief is to set aside the ex parte decree or an order,
yes,
then even at that stage, the real achievement is the relief. And if he has sought for a relief, and if the suit or a proceeding is revived after setting aside, then he has to again make a prayer. I don't know whether the CRO here permits the automatic impleadment.
Already, with you,
I do not know.
Your lordship, to that query, my answer is, I have already been impleaded and I have also filed my written statement.
No, there are two aspects.
Yes.
I do not know, civil rules and orders are here.
Yes.
Civil rules and orders are here.
Right.
Which talks about, I am talking about the other state.
Yes.
It says that there is addition allowed at a collateral stage or at the higher stage. Then after the removal of the suit, it is not there is no necessity of impleading him or adding him again. He will be deemed to have been added and will continue.
Yes.
But I do not know here.
Same thing.
If it is not a deeming provision, then after the restoration, he will apply for his addition.
I have already applied and got impleaded.
The soul is not is only sorry applicable to the court.
Yes.
Civil court. Sorry.
Sixth query, my lord, after the restoration, in a way, in the original 30 proceeding, I have filed a petition and it has been allowed and I have already filed a written statement. That stage is over.
You must call it some other.
When?
Any day.
You should have known.
15th, that's right. I need not file any rejoinder. 15th or last week.
15th, I have a difficulty. 16th.
16th.
Is there a Hindu Endowment Act or under
Hindu
Endowment.
Hindu religious.
It's a Hindu religious endowment.
16, 15, I'm the problem, let me 16, subject to 15. 16. 16. Madam, in this case, will not. In this case, will not. I am appearing for perform opposite pattern 8, 9, and 10. In this regard, only 8, 9, and 10. My name may be my name may be reflected.
Item 43.
Time to fight counter. Entry order counter. Entry order is there. Is minor. Out of the date, out of March minor. Yes. Out of March 25 euros.
Get 14 number 2. It is for 8. 2.
I am for 1, 3 and Diganta Das. 1, 3 and 4.
You are sitting there.
Yes, sir.
Start 6 times. 5, 3 times 5 is 5.
Only remote.
Item 44.
Item 44 is similar to item number 39, and they may be tagged up with that, and it will be that same day.
Yes.
7. Item 45.
Item 45, 46, 47. A similar matter has been listed on tag up matter on 5th of May with WPC number 18713 as a main matter.
Excise.
Service tax matter. 7340. It may be tagged up with that.
In item 46 and 47, I am appearing for the petitioner alone.
Millets, in item number 45, I am appearing for the petitioner through VC Millets.
Entry order to conduct.
Yes.
Millets, interim order is there in 45 also.
Yes.
Grateful Millets.
Tag to that.
39.
Separate.
The other is the
46, 47.
need matter is given
45, 46,
of a need matter.
May I call the next?
Yes.
Item 48. It's for hearing.
Your Lordship, on behalf of Mr. Partha Naik.
What is that?
He is on legs in another court, Your Lordship. He is on a criminal appeal bench, Your Lordship. So he had his matter today. Second bench, Your Lordship. But Your Lordship, I have information here that the last occasion about the well-being of the accused, Your Lordship, and there's no trace of him. The police have no trace of him, Your Lordship. Yes, Your Lordship.
Tabuk was affected earlier.
No, Your Lordship.
He was represented by somebody.
No, Your Lordship. Since the very first NBW was also issued against him, as far as it goes, Your Lordship, but he has come, Your Lordship. And there was publication also in the newspapers, Your Lordship, also. Yes, Your Lordship. Yes, Your Lordship. As I was looking through the records, it was issued
Something wrong, sir.
Again, Your Lordship, this is the instructions that I received.
Some genuine efforts have to be done.
There was some information that he was present in Gujarat, so an English daily in Ahmedabad also, the notice was publication.
Government criminal appeal.
Yes, Your Lordship.
Once the moment government criminal appeal is admitted, is listed or is registered, then he became an accused.
Yes, Your Lordship.
His status turned as an accused.
Yes, Your Lordship.
So it is not a matter of notice. You procure his attendance. State machinery has to procure his attendance.
Time for the one for the soul. Everything. It's not. It's he said no.
That's what act. And the G submits that the present whereabouts of the respondent is not known. It's in form, authoritated, eight 7/2002 that the respondent has been allowed to be enlarged on bail for rupees 10,000 with such conditions. For rupees 10,000 with two CBTs along with such conditions. But nothing appears thereafter on record. Sorry, thereafter by order dated 21 July 2006, the NBW of arrest was issued against the respondent. Till then, till now, said NBW of arrest has not been executed. The Superintendent of Police, Ganjam. It is Ganjam, na, madam?
Yes, Your Lordship. Ganjam
is directed to appear before this court on the next date to explain the reasons for non-execution of the order of NBW. Non-execution of the warrant, non-execution of the NBW. List on 1st May.
Item 49.
10:30, Your Lordship.
Come at this.
Yes.